card for a parking problem.
And 423.
Yeah, that's 4, I'll get a 28 from one truck when you're ready.
Go ahead.
From one truck, white Lincoln X-ray 985 should come back up next.
So you had 2000. Patrick Spalding.
10-4. If you can just put a little note in something like that, I'm going to be leaving a note on the vehicle advising him to remove it.
Fine. Fine. Rockingham 505. 505 enter vandalism case for Athens. Explain it. Soon to be X. Slashed her tires and has made threatening comments to her. She's concerned he might return.
Yeah, forgive this at 32.
10-4. You're assigned to a vandalism case in Athens. Can you copy the 505?
Yeah, 4. No, 3 in Depot Street. Truck's away at 35.
7435.
10-4.
10-4.
You can go 643 again.
143.
You go with that 43 you had. I didn't hear any, but I had just looks like we do.
10-4. I just wanted to know if you should be put back 76 to Cabana Circle or to the subject's address.
Yeah, I'll be 23 back on that town property case, and I'll be 76 to the Williams Road address to see if I can find the owner.
10-4. 449 1120.
449 1121, thank you.
10-4.
Code 4. 4.
Right, we have 535.
You have a great coach.
535.
Should be. You guys know if our woman who walked into a house. I'll slide up that way.
Caller is now been able to close the front door. He's now pounding on the door, trying to get in still. About 5 foot longer here. Got tight on. Number 21.
We have separation. Excuse me. Hey guys, good morning. Just had a quick call there from Kate. She'll be joining us shortly. She was mentioning that apparently Aiden doxed the jury foreman yesterday, which is not the first time. He actually, several months back when he was angry at the foreman, did everything but put out his name and saying that this guy should be targeted, he should be blamed. And then mysteriously, another account popped under his thread like minutes later to reveal the name. Now, you know, 2 plus 2 equals 4 here. You don't have to really understand. It's not a big mystery that that person was either Aiden under another account or someone that Aiden gave that information to put it out there. He just didn't want to be seen putting it out. But Kate's saying that he now maybe put it out yesterday. So if that's the case, you're almost going to wonder, like, what does this guy really want? Does he really just? I don't know what the law is on that. But what's his real goal here? To be pushing things like that? Is he's just trying to playing this game of brinksmanship with the authorities? I don't know. All right, so the documentary last night. We'll see what you guys thought about it. I had a few notes on it. Now, one thing that struck me was Karen made a weird point of saying she was talking about Jen McCabe, and she said, either I'm going down or you are. So she's made this into this weird spitting contest between her and Jen McCabe. Now that's really, really bizarre. But the important thing for me is that is kind of a kind of confirmation of something that Turtle Boy had said when he was mad at Karen early last May, and we revealed this in the admin chat. So he was telling his admins in the Facebook group. This was at the time when Turtle Boy was upset because Nick Rocco was going into court with Karen's family. It's before Turtle Boy had a media pass, so he couldn't get into the court without that invitation from Karen. And so he looked at Nick as someone that usurped him. And in addition, Nick Rocco was going on court TV. And so this was just torture for Turtle Boy. He hated it. And so he, at the time, threatened to take Karen down. And she had also been kind of freezing him out since he'd been arrested the second time and served his 30 days in jail. So she understandably had to distance herself from him, but he felt freezed out, and she really didn't appreciate the risk involved when it comes to freezing out Turtle Boy. So this guy will turn on anybody in a second. This guy would turn on a family member in a second. He's a psychopath. That's what they are. He doesn't have any actual human emotions for anybody else. So very, very limited intelligence, but very limited range of emotions. And so he was threatening to take information to Lieutenant Tully that would destroy Karen Reed. Yes, that's that same Turtle Boy. That same Turtle Boy was doing that. This came out in the admin chat. We revealed it, I don't know, maybe in December. And that was early May last year. Just as the trial was starting, Turtle Boy was threatening to take damaging information to Lieutenant Tully of the state police in order to destroy Karen. Such was his rage at not being allowed in court or being on court TV. Well, within that conversation, he told his admins that Karen herself was the one that sent Turtle Boy to the somewhat famous incident where he took a camera guy, Richie, to go and harass Jen McCabe at her daughter's youth lacrosse game. And so he went into the bleachers and started harassing Jen. But strangely, one of the things that he started yelling out to Jen was, did you think you could outsmart Karen? Did you really think you could outsmart Karen Reed? It was a very strange thing to say. I remember thinking that back then. And that was, when that came out, that was kind of a turning point for me where I said, all right, that's it. I have no use for this guy anymore, But why was he saying that? It was a really strange thing to say. And so Turtle Boy had said in the admin chat last year that Karen told Aiden to say that to Jen. She specifically told Aiden, when you go to the lacrosse game, say to Jen, did you really think you could outsmart Karen? Now that sounds like a really strange thing to say, right? Not a normal thing for a human being. Like, I can understand, at least on an intellectual level, you're trying to blame other people for your crime so you can get off. I'm not in any way justifying that. There's no justifying that, but at least I can rationalize it and say, all right, here's a person trying to stay out of jail, and she doesn't care who she takes down to do it. But what was the purpose of creating this personal battle between her and Jen McCabe? That's psychopathic. There's something strange going on there, if true. But when you looked at it as Turtle Boy saying it, I'm thinking, anytime you see something that seems a little bit strange, you have to question it, right? If it's something, if anytime you see a report, a witness account of something that seems a little bit that doesn't make sense, you should question it, right? Whether it's a villain or a hero in the story or whatever, it doesn't matter. But if it doesn't so in the screenwriting world, a rule of thumb is this: every character is a hero in their own story. So we look at screenplays and we look at fiction as though you got good guys and bad guys. But it's important to remember that from the bad guy's point of view, in his story, he's a hero. From Adolf Hitler's point of view, he's a hero in that story. From Joseph Stalin's point of view, he's a hero. That's generally how it is. So, but what is it here that makes it? Why is it that she's got this personal thing with Jen? That's a really strange thing. And so I had to say, all right, I'm on the fence about this as to whether, back then, as to whether or not that actually happened, because it seemed strange to me. So it was equally possible that it happened, that Turtle Boy was told that by Karen, or that Turtle Boy was making it up because he was mad. However, last night's show really kind of confirms that Turtle Boy is probably telling the truth about that, because this strange, in a documentary where she is choosing her words carefully, she is still weirdly saying that either I'm going down or you are to Jen McCabe. And she even used the word you. She didn't say I'm going down or she is. She says either I'm going down or you are. So through the camera, she is addressing Jen McCabe directly. Weird stuff. That does not happen. Normal people don't do that. Even if you take the position, I'm sorry about the cough drop. I have to have them in the morning sometimes. I'll get rid of it after a minute. Even if you take the position that you're on the fence about whether or not Karen did this, you really have to say that there's something strange about her personality. That even if Karen was innocent, why is she up there trying to turn this into a dick measuring contest between her and Jen McCabe? I'm sorry, I couldn't think of a female version of that. The alpha female contest, if that's better, between Karen and Jen. Why is she saying things like that? Now, we don't see Jen McCabe say things like that at all. So what is actually going on here? So again, when I see, that was stunning to me. That way, and not just stunning. To me, that was revealing, Karen saying that last night. That tends to confirm that Turtle Boy is probably correct. So that means that would make Karen directly complicit in witness intimidation. If she played a role in sending Turtle Boy to the lacrosse game, for instance, how did Turtle Boy know that Karen's daughter was playing at a lacrosse game? Right? It'd be interesting to find that out. Sure, he had minions all over the place trying to prove their loyalty or show something to that crowd. So we get that. But, Karen has connections all over Canton now from her time hanging there. We're not going to say their names, but there is a handful of people that became drinking buddies of hers at the Hillside Pub. And, these people became, so she has her own sources there. So Amy said she speculates that it's because Jen McCabe had the life and family that Karen wanted and couldn't have. I mean, maybe not just the life, not just the life, because it doesn't sound like Karen really entertained being a mom. It wasn't a lifelong ambition or priority for her. But there is that kind of alpha female thing where Jen is going to take everybody under their wing and be the social coordinator. She's the one that's inviting Karen to the party. She's the one that's saying, "Why don't you come with us?" Now, I think the most obvious and normal way to look at that is here's someone that's just being kind of a social coordinator and looking out for everybody. But from Karen's perspective, that looks like dominance behavior. From Karen's perspective, that looks like Jen is trying to be the alpha female, the one that's controlling everything around them. And for someone that's a psychopath, that's a threat and it's offensive to them. And so I don't think Jen would have realized that she was triggering those alarm bells within Karen because Jen's not a psychopath, so she wouldn't understand how they think. So I don't know. I found that to be, let me take this banner off. Now, there was some other interesting things. So David Yannetti is now underplaying, or at least in this recording, which was presumably last April, underplaying Steve Scanlon as a source. He went out of his way to say that Scanlon had no actual information, but that he just had theories. So it's interesting because all along in the past, David Yannetti has very trickily tried to portray in Clinton-esque words how he doesn't use the word whistleblower, for instance, but he'll describe a whistleblower in every way. And what he has said is that there's an informant that they think has inside information, but that has been silenced into fear. They're talking about Scanlon. It's Scanlon had no actual information, but he had picked up some scuttlebutt and went to them with that. But it's interesting to see that David Yanni has dialed that back now, maybe for legal reasons. Maybe he's worried about being sued by Scanlon. Now, because in the past, he would say, we have this informant kind of thing, but he wouldn't mention his name. But that now, in the context of having to talk about Scanlon directly, and actually, I don't even know if they use the name Scanlon. I think they just use gravelly voice. But still, the closer you get to talking about it specifically, maybe he was a little bit worried about almost time to start lining up the channel. All right. Just bear with me, guys. Lining up hopefully the ceiling fan. All right. So I found that to be an interesting change. Also, Alan Jackson said, I quote, jury selection, that's the trial. So that's going to be a focus of theirs. You saw them focus on the dismissed juror in their motion to dismiss most recently. So, so hold on a second while I try to log into my StreamYard. Just bear with me. Just want to make sure everything is lined up. Okay, now I just hold on one second. Now let's see. I'm gonna try. Well, all right, we'll go to the YouTube one first. The Channel 5 WCB news ended up being a good link last time. But I don't imagine they'll probably go into it until right when it starts. All right, let's see. The law and crime one is ready to go, but that one typically has a lower volume. And this camera is not live yet, so. All right, so I guess I'll just load on the for the moment. Okay. All right, so I got up the law and crime one for now, but we will, as always, adjust to whichever has the most volume. So we're still about 10 minutes away at least. They never start exactly on time, but we're in 9 minutes, it'll be 9 o'clock. So we got a little bit of time, but I will keep an eye out on this. And at some point, Kate and Jen and Matt and others will be here too, so they can kind of take the heat off me while I focus on the technology. All right. So the other thing, what else did I notice last night in the show? Interestingly, Karen now adds a couple of new pieces to the story, one of them being a piece of glass. She says that she took a piece of glass from John's nose, and that when she did, blood started flowing from it. Now, why would she tell this story? Even if it's again, I always try to say a good starting point in a story is that there are no geniuses, but there are no idiots either. Karen Reed is no idiot. And this is not something that she's saying under the heat of the moment. This is something that she's doing these interviews that she's carefully thinking about. So why is she telling us that she pulled a piece of glass from John's nose? I don't really have a good theory on that unless she's getting ahead of something that's going to come out. You know, to our knowledge, no piece of glass that was recovered at the scene had blood on it. So unless there's something new on that, which it doesn't seem likely there would be. So why is she telling us that she pulled a piece of glass? Because it, you know, in theory, that glass could have come from inside the house, I guess, but it's certainly much more likely that that glass came from the cocktail glass. So you have John gets hit at 24 miles an hour, and his arm snacks back. His arm, which is holding the cocktail glass, snaps back, smashes on the rear part of the car, leaving a dent in the panel exactly a forearm's length away. And that's going to send some shards flying. So one of them possibly stuck into John's nose. But I don't see how she could be telling this story as a way of suggesting that it happened inside the house. Because look, I've been in the middle of 1,000 fights as in my bar owning days, and I've seen a lot of glass flying. I've seen some wounds from glass. I've seen bottles thrown and smashed. I've had bottles thrown at me. I've never seen a piece of glass from a fight end up in somebody's nose or on their face. So I don't really understand exactly why she said this. Again, I'm going to go with the baseline starting assumption that there's a reason she didn't just slip up. But why? Why did she say this? I find it interesting. And she also added that Karen went back to the house. She had some details about what happened when her father told her, or her father added those details when his father told her that John was dead. And Karen asked to go back so she could say goodbye to the kids or see the kids. Let's say it that way. I don't think she used the word goodbye. So let me try to be accurate, to see the kids. But clearly she was going there to say goodbye, I would say. So she had to know at that point that she was going to be charged with this. She had to have a very strong suspicion. And why would you have that suspicion if you're innocent? If you know you didn't do it, if you saw John go in the house. So she goes up to gather some belongings up in John's room with her dad. Again, why would you do that unless you're not planning on ever coming back to that house? And why would you be not planning to come back to the house? So let's say Karen had stayed in Dighton for the night and had nothing to, and was never in Canton the night of that storm. And John still died. It was his day to go, and he died by some other way. He was in a car accident. Well, would Karen be coming over to collect her things? Would she be coming over to say goodbye? It doesn't seem likely, right? Because she says how much she cares about those kids, and they've been a part of her life for 2 years. Even if she might not be staying at the house anymore, she would still be a part of their lives, right? Why would she instantly be out? So I think this is, she tells these stories about what happened at the house because she knows it doesn't look good. It looks like she went back to that house because she knew what the people in the house did not know, which was that she had done this and she was going to be charged with this. And she was not going to be able to return there, and she wasn't going to see those kids again. And she said something to Paul O'Keefe's wife, Erin. I'm sorry, I couldn't think of her name. Erin O'Keefe. She said something on the phone with her so shortly later when she was on the drive back to Dighton, and she said, I forget if Erin called her or she called Erin. I think Erin called her. And remember, Erin and her were pretty close. And she said something, well, we're not going to see each other again. And Erin's like, why? So Karen knew then what really nobody else knew, that she was going to be charged with the crime. It's hard to avoid concluding that. And so I think this is why she was out there telling this different versions of this story. So now she's added these details where she's in the house and so you notice how she made a point of saying how she hugged John's niece. She doesn't say that she hugged the nephew when he came home. The nephew got home from a sleepover and learned that John was dead. When that happened, Karen and her family were there. Now, Paul has not told this publicly, but she knows because Paul has told Natalie and other people that one of the things that most kind of was a warning sign to Paul at that time, maybe the first one, was that when the nephew came home, and I think he was 10 at the time, and he was obviously inconsolable, everybody was moved by that moment except for Karen. So that's why she tells the story last night. I made a point of hugging the niece. So maybe she really did, but she showed no emotional support for the nephew at all. And so she's now trying to explain this behavior because presumably these kind of stories from Paul will be explained in the Netflix documentary. But at this point, actually at the time Karen's explaining this to Terry, that's last April. So she probably thought that this story was going to come out this summer, but Paul has actually stayed out of the news, so it hasn't. But this is the truth that she was trying to cover up from, or at least this is she's trying to deflect from Paul's story. So she comes up with this new story, new to us anyways, where she says that Paul said John looked like, she said what happened, and Paul said John looked like he'd been beat up, but that John's mother looked at them and said, I think he looked like he was hit by a car. And so Karen is trying to explain her, and this is a new development. In the past, she had just said that John's mother was eyeing her daggers, basically. And so now she's added a new detail that the mother actually said that. This is what liars do. They add new details to try to flesh out a story, and it can take time. So now they have this new detail that the mother has said that, and yet another new detail that a mysterious phone call came in. And when that phone call came in, all of a sudden, I think it was maybe Paul that took the call, but all of a sudden everything changed. Now everybody was looking at her funny, and she's a stranger in a strange land, and everybody's looking at that she's guilty. So, thank you, Mermac. Appreciate it. So just checking. So we're getting at 9:00 now. So I will feel better once we have a feed that has gone live. All right, we are about to get a feed that goes live. Give me 1 second. We have fanned. This is always our favorite part of the day when we have fan, because then we know. Then we know that action is imminent. But for me, I know I have a feed set up. So there's always been a little anxiety because sometimes these things don't get running and you have to search around for one. And Ashley helps me find one. So, we have more than fan. We have motion, and we have Turtle Boy in court. I think he has his own hearing today too. All right. So I have, as far as I know, I have not turned the volume. I mean, I have not turned the volume down. So as far as I know, there's no volume on this feed yet. So you guys can help me monitor this just to make sure we don't miss anything, make sure I'm not doing something wrong on the technology wise. Actually, let me turn on my other monitor. Karen is arriving. All right. So do you guys, this feed is the court TV feed. Does anybody seeing any volume anywhere? I'm just looking at chat. So let me know if anybody is seeing any actual volume. Okay, there we go. And we have the dude here today too.
If you go on the side, that'll be better, please. Like over there, is that okay? Thank you. How about down here on the end?
So at various points today and tomorrow, we'll have Kate, Matt from Boundless Millennial, and Jen Coffenaffer.
Welcome to Zoom for Government. Enter your meeting ID. Enter your participant, please enter the meeting passcode. You have joined the meeting as an attendee and will be muted throughout the meeting. The host would like you to unmute. You are unmuted.
So I suspect that this is going to be a long day, even if Alessi doesn't talk. That's just my suspicion. There's a lot of business before the court today.
Silas Rankins, I think. I got an email from Arca saying what the name said.
Let me see.
25.
Is this the red one?
Oh, you know what? One.
Oh, you have an extra one?
Yep, I don't have an extra one, but I'm not going to need it.
Here.
Nope, has to be up. Till we get going, then you can put it on.
So I do have multiple systems going, and as things can go with technology, sometimes, and some of these computers are decent computers, but sometimes things can overheat, get jammed up. You know how it is. So I can always switch over. I've gotten to the point now where I can switch over pretty seamlessly, and usually nobody notices when it happens. But if I'm away from the desk and there's something bugging out that I don't see, those people out there that have my number, please just text me and say, "Hey, dude, something went wrong." But but if you see it go wrong, and it looks like I'm doing something, you know, give me a minute to fix it, so I don't get flooded with stuff. So speaking a little bit about the documentary last night, just from a narrative flow production style point, curious what you guys thought. I thought they did a very good job actually so far, and just the way that it's set up, and you're trying to exploit. Is there something Colin's trying to say to me? I'm not. I don't know what is Colin trying to say. I don't know. I don't get it. Colin's usually in chat, so I thought they've done a very good job so far at this point. The way that it's put together, remember they're putting together a 5-hour documentary, multi-part thing, and the goal was to make it. Oh yes, Joe. Yeah, no, I've spoken to him since then. Thank you, Joe. And I got to review his thing, and yeah, he thank you, Joe. He reached out to me to say, "Oh, I wasn't on live, but I'm still watching." Once he saw it on the replay, he messaged me that morning, and then I went back and read his email. He did a good job with it, and I'm getting so it is getting to a point now where I'm getting a lot of emails. I do read them all. But some of them are long, even though I asked them not to be long. I guess I understand it. They have stuff that they want to talk about, but you wake up in the morning and you've got a dozen emails, and each one requires 5 minutes to read and 5 minutes to respond. Next thing you know, it's time for lunch. You know, so I'm doing the best I can with them, but I do read them all. There was some new stuff in the documentary, Mrs. J. No, obviously we don't expect any generally bombshells, but there was new stuff in the documentary. So we found out that Karen says that she pulls a piece of glass from John's nose at the scene, that when she started doing mouth to mouth, that she heard gurgling. She says that when she was in the house, that Mrs. O'Keefe said John looked like he'd been hit by a car, and then some kind of phone call came, that all of a sudden everybody was looking at Karen like she was guilty. So I thought those were kind of interesting. I thought it was interesting that Karen basically looked through the camera at Jen McCabe and said, either I'm going down or you are. I found that to be interesting.
Draw near, give your attendance, you shall be heard. State the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin.
Good morning, Ms. McLaughlin.
Morning, Your Honor. Adam Lally for the Commonwealth.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Giannetti. All right, so we have a lot to cover, but what I'm going to start with is a decision on the Commonwealth's motion to exclude employees of Arca. So I think I told counsel before that I had reviewed. So first we had full hearing from counsel. I heard from the lawyers. I heard from Mr. Alessi on behalf of the lawyers. I've read the transcripts. I've listened to the sidebar conference and read that transcript. And I've certainly read the pleadings. So based on all the evidence, I conclude that there has not been the candor required of all lawyers has not been demonstrated here. I find that there have been repeated misrepresentations made to the court by defense counsel, and I conclude that they were deliberate concerning the relationship with the Arca witnesses. They were made at sidebar, in open court, and in pleadings. And I think the record is pretty clear, and I find that on July 25th, 2024, payment was made to the Arca witnesses. Yet on February 26, 2025, in a pleading written by Ms. Little, signed by all three defense counsel, says the Commonwealth's motion to exclude these exculpatory expert witnesses, Arca witnesses, who were not hired or paid for by the defense, is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. The next page. Ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14, in custody of the defense relating to the Arca witnesses as ordered by the court. So I find or conclude that that was a material misrepresentation and that it was deliberate. So I find that there is a flagrant violation of the Rule 14 obligations. And before I decide which sanctions are appropriate, I need to see defense counsel and Ms. Reed at sidebar. I'm going to ask that the Commonwealth remain where they are. I'm going to seal this sidebar, but I need to have a colloquy with Ms. Reed before I figure out exactly what I'm going to do here. So.
Okay, guys, so I switched over in the middle of that to Channel 5 WCBB. It seemed like it was a little buggy. I couldn't tell if it was from the court or the court TV feed, so I switched over. This sounds pretty good, but this is pretty explosive. Now, why are they bringing Karen in on the sidebar? I'm going to get, I'm not a lawyer, but I'm going to guess that there are some options going to be put in play there. And I still predict that the judge will not remove any of these attorneys, but she may be informing Karen of some of what's her rights are here. So this is the first sidebar where you can actually hear the judge's voice. You can't make out the words, but I would imagine if you're in court, you can. Karen is at sidebar because these decisions affect her. If for instance, Little or Alan Jackson's pro hoc vice giving him permission to work on this case under Uniti's license, if they were removed, that affects her. So, or the judge may be saying, you have rights here. So she may be not removing them, but telling that Karen that egregious misconduct has taken place and she should have that right.
All right. So there's no greater constitutional right than the defendant's right to a fair trial, including a fair and impartial jury, the right to present a defense and confront witnesses, and the right to counsel, which includes counsel of her choice. So I've just had a thorough colloquy with Ms. Reed. I believe it was extensive and thorough, and she has expressed to me a strong desire to continue with her lawyers. Ms. Giannetti, is Mr. Jackson lead counsel? I just want to make the record clear. Mr. Jackson, are you lead counsel?
We don't define our roles in such a manner, Your Honor.
Okay, so because Mr. Giannetti is not pro hoc vice counsel, and Mr. Giannetti can try this case if need be by himself. All right. But Ms. Reed does have a strong desire to keep all of her lawyers, notwithstanding the Rule 14 violation and the apparent lack of candor, the findings and rulings I've made. So based on that, I am not going to revoke pro hoc vice licenses. I don't expect to have to address this again. Candor with the court is essential. It's the bedrock obligation of all lawyers who appear in this court and all courts in Massachusetts. A lawyer is only as good as his or her word, and I need to be able to take counsel at their word. So I'm not going to tolerate false statements, any stretching of the truth, no misleading distortions. There's no place for that in the courtroom. And Mr. Jackson, you stated this very eloquently in your closing argument last time. So, Commonwealth, I am denying your motion to exclude the Arca witnesses. Those witnesses can testify as long as counsel complies with their reciprocal discovery obligations. I will allow a full cross-examination, Mr. Brennan, and I will review any proposed curative instructions, limiting instructions, or final jury instructions. So that's my ruling on that. So we'll move on to Mr. Lessie. You didn't have a chance last time on the motion to exclude the testimony of Dr. Wolf. So I'll hear you on that.
Thank you, Your Honor. May it please the court. The proposed testimony supported by the Commonwealth of Dr. Wolf should be stricken in its entirety. The subject matter of Dr. Wolf's purported testimony by his own report and the Commonwealth's own motion is that Dr. Wolf will testify, is proposed to testify as to the cause and the manner of death of the decedent. That is the subject matter of the testimony. And as the court is well aware, in order for Dr. Wolf to be able to make testimony with regard to that subject matter, he has to demonstrate, and the Commonwealth has the burden of proof by a preponderance of the evidence, to demonstrate that he's qualified, prong one, and two, that the methodology is reliable, and specifically either that the methodology is commonly accepted in the relevant medical community, or that the proposed testimony can satisfy the 5 non-exhaustive factors of Daubert-Lanigan. The entire motion, papers, and supporting documentation fail to even allege that the methodology is generally accepted in the scientific community. It's not alleged, let alone demonstrated. In terms of his qualifications, it is essentially Hornbook law that to testify about the manner of death, as opposed to causation, this cause of death, you need to be a medical examiner, a forensic pathologist, or both. Conceitedly, Dr. Wolf is not a forensic pathologist and he's not a medical examiner. So I'm going to just put aside for the moment the cause of death. I want to speak specific because he's got to be able to show both, because he's opining about both. So there is no demonstration in the record that is before Your Honor as to how Dr. Wolf is qualified to talk about the manner of death. Dr. Wolf invokes a terminology called mechanism of injury. That's the closest he comes to talking about manner of death. And specifically in his report, which is Exhibit A to our motion, the entirety of his opinion is in that exhibit, NDA 02801. It is a mere 15 lines, 1 paragraph. And the applicable aspects of that paragraph is he says the following: based on the findings of his autopsy, his being the decedent's, it is clear that the mechanism of injury was a fall backwards, resulting in not only the basilar or skull fracture, but also a subarachnoid hemorrhage and contusions consistent with a coupe contra coupe mechanism. Mechanism of injury is not at all probative or even relative to cause of death. We're not talking about an injury here. We're talking about the manner of death. And mechanism of injury doesn't satisfy it. But the point first, Your Honor, is he's not qualified because he is a neurologist. His CV makes it very clear he's a neurologist, and his focus of his practice, by his own words, is based upon the precise invocation of radiation to treat incurable cancer. That's what his specialty is. That's what he currently does. So in terms of qualifications to talk about manner of death, he doesn't state the manner word, but he uses mechanism. He doesn't state mechanism of death. He states mechanism of injury, and mechanism of injury is irrelevant. So on qualification prong, Your Honor, it is completely lacking in the record that he is qualified. It's not enough to say you're a neurologist and head of neurology at a certain center. And this is juxtaposed next to the fact that the Commonwealth, the autopsy, which is very clear that those that are qualified, Dr. Stonebridge and Dr. Scorti-Bello. Dr. Stonebridge didn't even venture into the manner of death at all, didn't comment on it. Dr. Scorti-Bello, who is a medical examiner and who is board certified in pathology, she concluded that the manner of death was undetermined. So here you have the juxtaposition of a medical examiner qualified to render opinions in those areas, saying the cause of death is undetermined, and you have an unqualified neurologist not speaking to manner, but speaking to mechanism of injury. So in terms of the paragraph that I was just citing in his finding, he says, based on the findings of his autopsy, it is clear that the mechanism of injury was a fall backwards, resulting not only, et cetera, and then he goes on to say the head injury was clearly inconsistent with any type of mechanism of injury, such as a bat, hammer, or a car hitting him directly. Then what he goes on to further to go beyond his qualifications, he says the frozen ground was enough that when Mr. O'Keefe fell backwards, his injuries were sustained. Where is the support that Mr. O'Keefe fell backwards? A neurologist can't determine that is a manner of death. He provides zero bases, zero, for his conclusion that Mr. O'Keefe fell backwards. Where is that? And it's also not in the autopsy. And with regard to his qualifications to determine whether the ground was frozen, I covered that with regard to Mr. Gilman. You need to be a podologist. You need to know something about soil. He doesn't even begin to state how he concluded the ground was frozen. He wasn't there on the date of the incident. So there's no basis for that, but that is part of his opinion and methodology. And now to leaving his lack of qualifications, where is the citation to any study, any acceptance of how Dr. Wolf has come to his conclusions? There's nothing there. And this, Your Honor, is become a pattern of the Commonwealth where they put forth witnesses and they don't tether the methodology, if you can discern it, to common acceptance or the Dalbert-Lanigan factors. So in terms of both prongs, Dr. Wolf fails because the Commonwealth has not even begun to meet its burden. I would like to also reference what we just received last night, which is an article that was co-authored by Dr. Wolf. And I want to note and this is fractures of the classification and clinical features. This is 35 years old, and it is notable both for what it doesn't say and what it does say. First, what this article doesn't do is it doesn't talk about how one determines what a mechanism of injury is. So I'm even going to assume for the moment the parlance of Dr. Wolf, mechanism of injury. And if Your Honor would look at, please, page 593 of the study. And it's basically a meta-study. They went back and looked at a lot of data and information, but it says under results, second paragraph, the mechanisms of injury were similar for all three fracture types. Motor vehicle and motorcycle accidents were the most common mechanisms, accounting for 47%. And then it goes on and it says 3 patients were victims of falls. But what this article stands for is that those were all known mechanisms of injury. It was determined before this study even occurred what the mechanism was. This study is not how does one determine when it's unknown what the mechanism of injury is with regard to a decedent. And that feeds back into the lack of qualifications of Dr. Wolf, because we're not given one example of where Dr. Wolf, before his report, his one paragraph report on conclusions, of when he's ever done this before. It's not stated that he's ever taken a decedent and determined the manner of death. And I note that this study talks about mechanisms of injury, which scientifically is completely different from manner of death. And what it appears the Commonwealth is trying to do is to back into manner of death through the parlance of mechanism of injury, and that is not at all probative of manner of death. And lastly, this study only stands for the proposition of mechanism of injury. What they looked at is once the injury occurred, what were the mechanisms that were occurring through the brain? What happened inside of the brain that led to the various injuries? So this study doesn't at all, one, support any methodology, number one. It doesn't stand at all that this is the methodology for how one determines in a decedent what was the cause, because the cause of the injury was already determined going into the study. And it also doesn't state anything about the paragraph that Dr. Wolf has explicated in his report. And I will conclude with 2 points. Dr. Wolf says, based on the findings of his autopsy, it is clear. Well, the autopsy doesn't come to any conclusion on manner of death. The autopsy doesn't speak to mechanism of injury. So it is a non sequitur, Your Honor, to say that based on the findings of his autopsy. And we know from Dalbert Lanigan, you've got to apply your methodology to the facts and evidence in the case. And the only facts and evidence that Dr. Wolf uses, by his own words, is the autopsy, which doesn't support at all what he is stating in his report. The second and last point, Your Honor, is that it is not sufficient in the case law in Massachusetts. It's not sufficient under 702 for someone simply to come in and say, I'm a neurologist, I therefore know the brain, and then take the leap from that foundation into a conclusion with regard to manner of death. So in sum, Your Honor, he's not a medical examiner, he's not a forensic pathologist, he has not stated any experience whatsoever in doing what he's doing here, meaning to determine the manner of death of a decedent. And his methodology is completely unsupported. We only have one article, and I've gone through why that article is insufficient. So we would request, Your Honor, and urge the court to exclude Dr. Wolf from testifying in matters beyond his kin. And in the alternative, we would request an evidentiary hearing, because we and the defendant has a constitutional right to cross-examination. And this is the same with Mr. Gilman. It's the same with other experts where there is no statement of the methodology, as here, there's none, and there's no tethering to a study. And how is it that one can cross-examine a witness that doesn't even begin to approach the two prongs of the Daubert inquiry?
All right, thank you. Mr. Brennan?
May I?
Please.
Attorney Lessie mistakenly misstates Dr. Wolf's credentials. Dr. Wolf is not a neurologist, he's a neurosurgeon. He's not simply a neurosurgeon, and it's not that he's a renowned neurosurgeon, but he has over 35 years of experience as a neurosurgeon. In addition to his opinion, you can see that Dr. Wolf has an extraordinary history of experience as a neurosurgeon. His CV is attached. In his internships as a neurosurgeon, he engages in an internship in pathology, neuropathology. We can see from his major research interests includes treatment of head injury, spinal cord injury. Dr. Wolf was the leader and director of the Miami Neuroscience Center for 17 years, from 1993 to 2011, the busiest neuroscience center in the country. He has treated tens and thousands of patients with head injuries, surgeries. His professional memberships are too long to list. Page 3 of his resume. His research is broad and precise and specific to head injuries. We can see in his research listed on page 4, he's a principal investigator in THAM treatment of brain tissue, acidosis in severely injured patients, principal investigator, PEG, SOD, and severe head injury. Improving outcomes in severe head injury, PEG, SOD, also principal investigator, IRB protocol, brain pathology. He is well published. His book chapters that he listed anyways, list 16, many of them dealing specifically with head injury and brain injury. Book chapters include head injury and difficult medical management, pediatric neurosurgical emergencies, complication of head injuries in adults, imaging of craniocerebral trauma, imaging and trauma and critical care, emergency room assessment of head injury patients, intracranial injuries. He has numerous journal articles, a slew of them specific to head injuries. Intracranial pressure, number 2 on his journal articles. Initial management of brain and spinal cord injuries, number 9. Number 16, which is the document that I produced to counsel last night, listed in his journal articles, number 16. Fractures of the clivus, classifications and clinical features. His journal articles are numerous, too numerous to go through, but you can see that he is well published, over 70 articles. His presentations, specifically on fractures, basal type injuries, number 5 on page 13. Number 9, neurosurgical management of traumatic brain injury. Number 10, acute head injury. And the list goes on. Over 90 references. Lectures and meetings, many of them dealing with head injuries. Over 100 lectures listed for reference, actually over 130, and a number of web publications. So this neurosurgeon who has this extraordinary experience is qualified. The ability to testify about head injuries and medical diagnosis and cause of death is not limited to a pathologist. In fact, I would suggest that the experience of Dr. Wolf is far superior to any pathologist. The difference is a pathologist treats patients that are already dead. Dr. Wolf treats patients that are in trauma, who some survive, and many die. So he is intimately familiar, not just with looking at a deceased in a lab, he's intimately familiar with assessing the injuries after they occur, diagnosing what the injury is, and an attempt to save the person's life. And so he's well attuned after tens of thousands of surgeries to understand the causation of a brain injury and what causes death. Looking at Dr. Wolf's report, although short, it is clear that the injury that was occurred by Mr. O'Keefe was an injury known as counter-coup. And I dare say the defense proposed expert, Dr. La Posada, is not in disagreement with that. To understand counter-coup, it occurs from a fall backwards on the ground. It can't occur from a bat or a punch or hit. There's not enough force. It occurs when the back of the head hits the ground and then the brain shifts to the front of the head. That is what the autopsy reports show. It may be that the medical examiner for the Commonwealth didn't have the same level of experience and didn't diagnose it, but this expert does have that expertise, and it is no different than the pathologist that's proffered by the defense. The periorbital ecchymosis that is directly related to the basal fracture, the swelling around the eyes, no different than Dr. La Posada's opinion, exactly the same. One thing he doesn't say is that the body was moved. There was no evidence or information for that. He doesn't extend himself as a detective or put in unplausible theories in his proposed testimony. He is intimately familiar with counter-coup, having treated tens of thousands of patients, and he understands in counter-coup how it can lead to suffocation at the top of the spinal cord. And so his opinion is clearly supported by his extraordinary experience, his writings, his history. It can't be that his ultimate conclusions of counter-coup and ecchymosis, periorbital ecchymosis, is in dispute. It seems that the defense simply prefers the original medical examiner for the Commonwealth. But we expect to call Dr. Wolf, and I would suggest that he's more than qualified.
All right, thank you. Mr. Leslie, anything final?
Yes, thank you, Ron. Mr. President. Thank you. Your Honor, I'm going to note what Attorney Brennan did not state. He did not address at all how the methodology, to the extent it's discernible of Dr. Wolf, is commonly accepted or it satisfies any of the Daubert factors. And that is the fatal aspect of Dr. Wolf's opinion. It's not stated. You have to have either common acceptance or satisfaction of the 5 non-exhaustive Daubert factors. It wasn't addressed, and I think it's reasonable to conclude that it wasn't addressed because it doesn't exist. That alone dooms Dr. Wolf's opinions. I will stipulate, for purposes of this argument only, the cause of death prong. Let's assume, just for purposes, just to focus on manner of death, let's assume hypothetically that Dr. Wolf is qualified to testify about cause of death. Mr. Brennan did not address at all his qualifications to discuss and opine on manner of death. And that is the distinction I emphasize, Your Honor. Manner of death, he has not stated one qualification on manner of death. So the defense urges the court to draw the distinction, to limit his testimony to cause of death, not manner of death, because we know, and we cited the Graham article, which is attached to our motion, which specifies who is qualified to talk about manner of death. Because what does manner of death do? It takes into account all the circumstances surrounding it, the crime investigation. That's what medical examiners and forensic pathologists are qualified to do. Attorney Brennan cited that in his CV, there's a reference to an internship in pathology. I looked, I didn't see it, but let's assume that it exists. Let's assume he has an internship in pathology. That does not qualify him to engage in manner of death 40 years later without any experience from that internship all the way until 2025. Lastly, Attorney Brennan goes through numerous studies, and I appreciate that he did because the CV is almost endless with meetings, presentations. There's 4 peer-reviewed articles. That's it. 4 peer-reviewed of Dr. Wolf. None of them address or come close to the topic that he's talking about. My last point is this with regard to Dr. Wolf's qualifications and what his practice has been. And Attorney Brennan concedes it by his own words. He said cause of injury. And again, for purposes of this argument only, I will concede cause of injury. But manner of death was not addressed by Attorney Brennan. It's not addressed in any of the qualifications of Dr. Wolf, and it's not addressed in terms of the 1 paragraph that we have. And for something as significant as this, 1 paragraph that doesn't address common acceptance, methodology, Dalbert factors, Your Honor, I don't know how a record is even begun to be established for him to be qualified or to opine on manner of death. So we would urge Your Honor to find that he is not qualified to testify about manner of death, that mechanism of injury cannot be manner of death, and that he be so limited to the extent the court desires and concludes that he has some relevance here. But in terms of all of the record that's presented, including the CV, etc., there's not 1 instance where we see that Dr. Wolf has even approached determining cause of death or manner of death at all. So I don't see where there's a record to find him being able to do that for the first time in charges of this nature. Thank you.
Okay. Do you want to respond at all, Mr. Brennan?
At some point, arguments become semantical and theoretical, but not practical. This doctor has treated thousands and thousands of patients, many, unfortunately, which have died. And as a neurosurgeon, engaging in the operations in the study of the brain and the patients, it is obvious that the neurosurgeon would understand and appreciate why his patients are dying, because that is part of the study of trying to save them. So for him to reduce on a piece of paper that the manner of death is based on my thousands and thousands of patients and my years and decades of experience, seeing firsthand many of these patients I cared for or tried to help died, and this is why. Technically, he could do that if that satisfied Mr. Alisi, but that is so unnecessary because it's obvious. Thank you.
Okay. Thank you. All right, so we have a series of motions in limine. I'm going to start with defendant's motion to present the demonstrative exhibit on Christina Hanley's testimony. It's paper 558. Is there an objection from the Commonwealth on this?
There is an objection.
All right, so I'll hear the defense on this motion.
Thank you, Your Honor, if I may. This is a relatively straightforward and relatively short.
I have a question. Did you use this last time? It looks like
we attempted to use it. We had it last time. It was shown to the witness, but it was not allowed to be introduced. And all we're asking is for that next step, that it be introduced into evidence
Did she adopt it?
She
Was
did.
there, okay.
She did indicate, and that's part of my argument, Your Honor, which
So I'll go ahead, I'll hear you.
I'll truncate it. It's a relatively simple request. We just want to use the chalk that was prepared in the first trial. No dissimilarity there. It was disallowed for use by the defense to be actually used, to be admitted, but it was shown to the witness. It was not shown to the jurors. The evidence, as the court will recall.
So let me just have, so you're just trying to use it as a chalk, not an exhibit?
No, we would ask that it be used as a chalk and an exhibit that's introduced. I'll take the chalk if the court wants to break it into two different pillars, but we believe that once the witness, and I anticipate based on her prior testimony that she would adopt it one more time for its authenticity or its accuracy, I should say, that it be used as an actual exhibit that goes back with the jury just for their help. The court will remember it's a very complicated.
So let me just, with that, if I allow it as a chalk, is there an objection from the Commonwealth?
Would be a partial objection to a chalk, some of the labeling. I have less concern of a chalk as I do an exhibit.
I mean, so we can take it in two steps. I certainly don't need to decide now whether it's admissible, and I couldn't, but what's the nature? Is this something?
The court will call this deals with glass. Christina Hanley spoke at length about her analysis of pieces of glass, other materials as well, but specifically as it relates to the glass, there were more than a dozen pieces of glass that she testified to. They were variously found in different places at different times by different people, and they're assigned a relatively complicated set of numbers that she utilized in her analysis.
And this is what you explained to me was the 47 pieces of glass that I asked you about last time, right?
This is more attendant to the glass in the bumper.
Okay.
The glass in the bumper, the glass that was found at 34 Fairview, as opposed to the lens material that were the 47 pieces.
Okay.
These were a bunch of pieces of glass that were originally that originated from multiple sources. Some matched each other, some did not match anything else. Some were from the same source, some were from multiple sources and different and distinct between and among each other. We reduced the very complex, the court may remember she talked about 7.14-B matched or didn't match 7.13-C, and it was very numerical and very difficult. It was difficult for me to follow. It was even difficult for the witness to follow because she continually had to resort to her own report as she tried to maintain her accuracy. So
do you have the day of her testimony?
Oh gosh.
Ms. Little, do you have that transcript pulled up?
Yes, one moment.
So obviously, I remember her testifying. I remember seeing this previously.
I've got it. June 5th, 2024, Your Honor.
Thank you very much.
Thank you, Ms. Little. The court will recall, and I think it's clocking with the court's memory, that we did use the demonstrative aid. We walked up to Ms. Hanley. We showed it to her on the witness stand, and she did adopt it. And she indicated that once she studied it, it was in line exactly with her testimony. It's an accurate visual representation of that evidence, and it just makes it a lot easier for the jurors to find some sort of linear logic to the evidence, what matched what and what didn't. And all we're asking is that we'll use the same aid, the exact same aid that we did last time, and just ask that it be used as not only a chalk, as Mr. Brennan said, he may have a slight objection to that, but also we would ask for the next step, which the court doesn't have to decide now. I think waiting on Ms. Hanley's testimony would be apropos, and then we'll ask for its admission at the right time.
All right. What's the objection, Mr. Brennan?
This witness has a report, and a report is not admissible and can't be shown to the jury. And so to have the defense summarize her testimony when she's not allowed to put her report in herself seems a bit imbalanced. There are references on this potential chalk that lists troopers' names. Those names shouldn't be on there, but also it doesn't give the full picture of the actual testimony. The issue regarding glass, I expect, is going to be a issue in the next case. And I say that because we learned last night for the first time on a public hearing of an episode that the defendant suggests that Mr. O'Keefe took her vodka soda glass out of her car. Now, that is the first time we've had any statements from Ms. Reed suggesting that. And also, there was another statement regarding a claim that Ms. Reed pulled glass from John O'Keefe's face. Never heard that before. So we have this evolving or new testimony or statements about glass. And so I think first, I'd like to consider this new information that we just learned last night. And secondly, I am reluctant to agree to a simple summary of part of the witness's testimony that has not only labels on it, but does not, from my perspective, clarify anything. I'm not opposed to chalks. I think chalks are helpful for both sides. And I think the liberal use of chalks is helpful. But I don't have confidence this chalk accurately summarizes the witness's testimony. I'm open to discussing chalks with the defense and perhaps learning why they think this is helpful and important, but looking at this chalk, it does not look clear to me. And I do think that the evolving nature of glass in this case is going to be an issue. And since I've just learned this information, I want to give it some thought.
Okay. All right, so Mr. Jackson, what I'm going to do is just hold off and see where the evidence is, what the two of you talk about. Maybe there's some agreement you can come up with regarding this. I need to hear more of the evidence again.
I understand.
And I'm going to read the transcript, so that will help me with
I think
this.
it makes sense. Mr. Brennan indicates that the chalk was not helpful to him. With all due respect to Mr. Brennan, it's not really his understanding of the chalk that is going to sort of seize the day. It's Ms. Hanley. So I do think that if the court would keep an open mind.
Sure.
Ms. Hanley testifies, then that would be the appropriate sign.
So I'll take no action on this, and maybe it's something we can address the day before she testifies or something as it gets closer.
Sure.
But the two of you should talk.
Sure.
I'm open to working with them if there's something they want to explain.
All right, great. Thank you. All right, so no action taken on paper 558. So one question, the next motion I have is defendant's motion to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. The Commonwealth has a sort of maybe a similar one that I'm not sure. The Commonwealth's motion eliminate to admit the victim's out-of-court statement relating to his state of mind. So the Commonwealth's Binns and Qualls motion, does that address the Aruba witnesses? I'm just wondering if they're hand in hand. So the paper number on the Commonwealth is 585. It's got your 11 on it, though. So the defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial prior bad character and propensity evidence. It deals with the, let's just say the Aruba witnesses. I don't, Marietta Sullivan, Laura Sullivan. Does this, Ms. Giannetti, I think this was one filed by you, maybe it wasn't. Does this include the children as well?
This does not. This is
Okay.
limited. This argument will be limited to we'll call it the Aruba incident.
Okay. All right. So given that, that might not include the Commonwealth's number 11, the Qualls, Binns, the defendant's statement, the victim's state of mind as it goes to the defendant's knowledge and ability, likelihood to act on that state of mind.
The defendant,
So I just want,
I didn't mean to interrupt, Mr. Brennan. Do you want to?
so I just want to know if that is part of the Aruba one.
Okay.
so our statements relating to Mr. O'Keefe's state of mind is broad. It would have included the Aruba, but I can make quick work of this. We
Okay.
do not intend to introduce evidence about the Aruba event.
Okay.
I reserve the right, if the defense opens the door, then we may proceed with it. But in our case in chief, we don't intend to introduce any evidence from the Aruba event.
Okay.
Shortest
There we go.
argument ever.
All right. All right. So, Mr. Brennan, you can have a seat again and we'll go through the defendant's ones. That's very helpful. So I will endorse it as Commonwealth does not intend to introduce in its case in chief. If that changes, Mr. Brennan, you need to come to sidebar well in advance, okay? After telling counsel.
Understood. Thank
All
you.
right. All right, so that was 5:59. The defendant's motion eliminate for review. Is the Commonwealth seeking a view as well?
We did not move for a view, but we do not object if the defense wants a view.
Okay. So who's going to argue this for the defendant?
I am, Your Honor.
Okay, so what's different this time around is you're asking that Ms. Reed be permitted to attend.
Yes, Your Honor.
So I'll hear you.
Your Honor, the defense is requesting that it exercise its broad discretionary powers to allow a view under Massachusetts General Law 234A.
So I'll allow a view.
Okay.
Okay, but let's talk about your client attending it.
Yes, Your Honor. There was a request in there for Ms. Reed to attend. That is something that's allowed under the law.
Mhm.
If
How do you propose that's done?
if it's possible to have separate arrangements for her to be there, vis-a-vis some other transportation so that they're not all on the same bus. If the court can make that accommodation, we would appreciate it. But the most important thing in this case, Your Honor, is that there be a view of both the vehicle and 34 Fairview Road.
All right, so the Commonwealth's not objecting to a view of the vehicle and 34 Fairview, correct?
I'm not, but I do not think the vehicle should be at 34 Fairview.
Okay, what are you proposing for that?
We could make arrangements and make suggestions, but it's not going to replicate the circumstances of that evening. And so it creates an image that is inaccurate. So I do not think that the vehicle should be sitting in front of that home in totally different lighting conditions, timing conditions. And I think it can be misleading.
All right, I need some suggestions. Why don't we table this for a bit, even if we do this one tomorrow? So one of the concerns I have about just logistically, people will have to stay away. When Ms. Reed's in court, there are a lot of people who come to court. So I need some assurances that there will be people kept at quite a distance. A separate car is fine. Would counsel plan on being in the car with her?
That would be fine, Your Honor.
So I need some proposal. So I need more information from both. So Mr. Brennan, I'd like you to come up with a proposal about viewing the car, a separate place or a separate time. It would be ideal if we could do it at the same time, but at a separate place. If that's what we decide, we may have to do it all at once.
I do think it's important, Your Honor, that the vehicle be at the scene just for dimension purposes so that the jury can get a sense of what it would have looked like at the scene. And I think just for convenience purposes, it saves a lot of coordination on the court's part and in terms of juror time by having it all happen in one fell swoop.
Okay. All right. So let's try and figure out some of the particulars. I would like to have Ms. Reed be able to attend. So let's figure out some particulars. All right, so defendant's motion eliminate to exclude certain witnesses before and after testimony. That's 462. And I think we can address the Commonwealth's motion for sequestration that moves to exempt family members at the same time. So who's arguing? 562. Did I say 4? Sorry.
Yeah.
562 and 576. So Ms. Little?
Thank you, Your Honor. I'm handling the motion to exclude certain witnesses. The court has broad discretionary power to sequester witnesses before, after, and during their testimony under Massachusetts Rule of Criminal Procedure 21. The defense respectfully requests that this court issue an order for sequestration in keeping with what the Commonwealth also requested. But additionally, excluding Brian Higgins and members of the Albert and McCabe families after they testify.
So do you mean after the evidence is closed?
I mean, after they've taken the stand.
So after they've taken the stand, but so witnesses are sequestered not to influence any testimony. So once the evidence is closed, just before closing arguments, are you saying they should not be permitted to come into the court for closing arguments?
Yes.
Focus on that part of your motion.
Yes, Your Honor. We're asking that they not be able to attend closing arguments, and this is why. As the court likely recalls, at the first trial, members of the Albert and McCabe families continued to attend court after their testimony. During closing arguments, Colin Albert, Ryan Albert, and Jennifer McCabe were all seated in the jury box with the O'Keefe family. At least one juror who was seated in this case indicated to a reporter at Vanity Fair that she felt intimidated by their presence at closing arguments. Your Honor, a sitting juror reporting feeling intimidated by the presence of third-party culprits towards the close of the case is highly concerning.
Was this a deliberating juror?
I don't know. She was, or he or she was anonymous.
Okay.
And Your Honor, that was by design. There is information that the Massachusetts State Police and the District Attorney's Office wanted to have the third-party culprits seated there during closing arguments. And so on that basis, the defense is requesting, in order to protect there from being any sort of undue influence or intimidation, or even just the potential that a juror might feel that way, as we know at least one did in this case, we're asking that they be sequestered after their testimony and during closing arguments.
What's your position on the Commonwealth's motion to exclude the family members of both the defendant and the victim?
I believe that the sequestration order, yes, we join in that request.
Okay.
The only exception I would note is that experts should be able to obviously watch other expert testimony that deals with their.
All right. So obviously is not something it should be in a motion. Okay. If you've got an agreement that each other's experts can be in the courtroom during the testimony, that's one thing, but it's not obvious that they're permitted. Okay.
I just wanted to make sure that that would be excluded from the order that the Commonwealth proposed. Because the way that they wrote it, it says all witnesses. And I'm guessing that, and I won't speak for Mr. Brennan, but I'm guessing that they will want their experts to watch our experts and vice versa.
All right. So you all need to talk. All right. And if there's a disagreement, you need to put it in writing. Generally, experts are permitted, but it's not a given. Okay. All right, Mr. Brennan, do you want to weigh in on people being able to, I'm concerned about after the evidence is closed.
I think it's unfortunate that not only a time-honored tradition, but an entitlement for a witness after the evidence is closed to come into the closing and watch the closing. The defense tries to take an opportunity to provide an unsolicited bashing on their targets. They name Higgins, Albert, they invoke those names, they characterize third-party culprit, and they suggest that some anonymous person was uncomfortable. It seems as though the presentation has a deliberate point to promote a cause, but doesn't have any sense of balance or fairness whatsoever. Witnesses, all witnesses from either side should be able to come into a courtroom after the evidence is closed, the sequestration order has ended, and watch a closing. Grace can be offered in these circumstances sometimes, and that's what I've tried to do in my motion. Ms. Reed has 3 potential family members who are potential witnesses for the government. And certainly I would have a right to try to ask the court or insist that they should be sequestered. But I've specifically asked that they not be sequestered. I think that an accused has a strong need to have family support in the courtroom. It's not in the benefit of the government or the Commonwealth, but it's fair, it's just, it's graceful. And I think that Ms. Reed's family should sit through the court testimony, even if they're called as witnesses, as should Mr. O'Keefe's immediate family. The idea that witnesses should not come in after a evidence rests and during a closing, not only does it seem quite unfair, it doesn't seem to have any basis in law, in justness, in courtesy. And so I ask you to deny the idea that these targets of the defense should attend the closing. But I do ask you to endorse my motion that would allow family members to have the benefit to sit through the court proceedings, even if they may, or even if they do become witnesses.
Okay.
Your Honor, if I could address one issue.
Sure.
There is some additional information. I was hoping we might be able to address sidebar because it is subject to a protective order, but I would like to make a record.
So as everybody might remember, during closing arguments in the first trial, multiple witnesses were brought in to sit with John's family as a show of solidarity. And I think the idea was, by the prosecution, was to show that, look, the defense is accusing these people of being the real killers, but here they are sitting as the special guests of the victim's family. So it's a way of emphasizing that the victim's family doesn't see them as killers, or even suspiciously as killers. I think it was also, the purpose of it was to remind the jury that what's at stake here is more than just justice for Karen and for John, but that these victims that have been falsely accused by this unethical defense team, that they're victims too, and they wanted to remind the juror of that. Now, I don't know if it's an effective strategy. I honestly didn't think at the time that it was, and I still think it probably was not. But there's really no way to know unless you're able to talk to all 12 of the jurors and see what their different reactions were to it. And in theory, it shouldn't matter at all. The jurors should not be intimidated or sympathetic or any of that. They should be just weighing the evidence. So we began today with the bombshells, judge coming right out of the gate and accusing the defense of not only of a lack of candor, but of misrepresenting the truth and the facts, not only in court, but at sidebar. That's a big deal. But yet she did not remove the pro hoc vice, allowing them to remain on the case. She brought Karen up for the sidebar, and it sounds like it went, all right, forgive me. I have a track record on this. My predictions on these things do tend to usually come true. And so I predicted this a long time ago. But it's just kind of common sense, and that can get lost in these things. That the judge did not want to take
a closer look at both of these and
her lawyers away.
later.
No.
All right, so Ms. Giannetti, I think this next one might have been yours. I could be wrong again. Maybe it's just that you filed some. It's paper 565, defendant's motion eliminate to prohibit testimony regarding funds paid to experts for purposes of voir dire.
That's also mine, Your Honor.
Okay.
I believe the Commonwealth has indicated that they will agree to that.
Okay. All right, so paper 565, allowed by agreement. So 566, defendant's motion for panel voir dire. Who's arguing that?
That's me, Your Honor. Thank
Okay,
you.
so all I need you to really focus on, of course, I'll give attorney conducted voir dire, but why don't you focus on panel voir dire for me?
The request is pretty straightforward. We would maintain a categorical list of topics that is in line with the statute, previous experiences with the criminal legal system, characteristics of the case, including media attention, things of that nature, biases in favor of law enforcement or vice versa, personal beliefs about driving under the influence. We think that's attendant to this particular case in particular, involvement in any relationships involving domestic violence, involvement in motor vehicle crashes, those categorical issues, whether they've ever been victims of violent crime, and their general ability to be fair and impartial in light of Ms. Reed's constitutional rights to.
Okay, well, we covered all of that last time as well, right?
And that's exactly right. So we're not asking to change the categorical subject matter. We just believe that a panel voir dire conducted, at least in part, with limitations, obviously, time limitations and subject matter limitations by the attorneys, would be of great assistance to both counsel, both the Commonwealth and the defense, in determining jurors' ability to sit through an extensive trial, a complex trial, and something that's going to be obviously hotly contested. The chemistry between and among jurors is more borne out if there is at least a modicum of panel discussion between and among the jurors and counsel who will be handling the case on behalf of Ms. Reed and on behalf of the Commonwealth. We don't think that there's any prejudice to either side, certainly not to the Commonwealth, certainly not to us. I think all of us would benefit, including the court, would benefit from being able to panel a fairer and more comprehensive jury.
Okay, it's the Commonwealth's position.
Of course, we defer to the court. However, we prefer a questionnaire. If we have a panel voir dire, there will be quite a bit of contest on the subject areas, the limitations, the parameters. I wouldn't say anticipate, but I worry that it will digress into trying to craft the argument, the direction of argument in a way that's favorable to each side's cause. And that really isn't the purpose of it, but that seems to happen in the limited times I've engaged in it. And so I think the questionnaire is more structured. It allows for all the different subject areas that are important to both sides. And I may misunderstand, but I think the court allows follow-up on questions where there is any inquiry or concern or follow-up that's reasonable and necessary. And I understand that that has been a liberal application, and I think that suffices.
The only thing I would say to that, if I may speak from here, the only thing I would say to that is I completely agree. I think a questionnaire is enormously helpful, especially as it pertains to a panel voir dire. And quite frankly, Your Honor, in my experience, and that's what we do where I'm from, is panel voir dire consistently. It's faster. It's actually much more efficient to do a panel voir dire than it is to do an individual voir dire. That's all I'll say about that.
So I'm a huge proponent of panel voir dire in the right case. My biggest concern here, frankly, if we didn't have the inordinate amount of publicity on this case so close to trial. I heard that there was something last night. It's been in the news, right? And it's continuing. It's because of that, I'm afraid it's just going to blow up the panels. So, and I have a lot of discretion here. I'm not going to allow panel voir dire. I will allow a robust, as I did last time, voir dire at sidebar. We're also on for final trial conference today and tomorrow. So I need a list of witnesses from the defense. I need you to fill out a report so that we know exactly what is still left that we have to deal with. And jury voir dire is a very important part of this. So I expect, as last time, to be able to use a questionnaire, but I want you to agree to it. And if you can't, I need that. I need that by the end of today if you're not going to agree to it. Have you proposed a questionnaire? Have both sides talked about a questionnaire recently?
We haven't, but we do have the advantage. Both sides has the advantage of the one from last year. There may be some adjustments, but I think we can act on to start with.
So let's do that. And what Mr. Brennan's new to the case, what I may When I need in a questionnaire is it has to be one page, both sides, no more than one page. At the end of our hearing tomorrow, I would like to talk about the particulars of it. We have a huge amount of jurors coming in, and I have some ideas on how we might best utilize that with the questionnaire, but I need to talk to counsel about that at the end of all these hearings today. All right, but just to be clear, no panel voir dire on this case, unfortunately, I think because of all the publicity. And we'll do extensive voir dire at sidebar and the questionnaire. So 566 then is denied because it's requesting panel voir dire. 567, defendant's motion for order prohibiting the Commonwealth and its agents from speaking with or having contact with any witnesses once they've taken the stand. So is there an objection to that, Mr. Brennan?
There's not. I believe that rule should apply to both sides. I have no objection.
Okay. Mr. Jackson, do you agree it applies to both sides? Ms. Little?
Thank you.
Okay. All right, so that, Mr. Clerk, 567 allowed as to both sides. $570, defendant's motion eliminate to exclude irrelevant, inadmissible, and prejudicial evidence regarding alleged harassment and/or intimidation of witnesses. All right.
Thank you, Your Honor. The first trial, I'll note, was riddled with what we believe to be inadmissible and highly, highly prejudicial testimony from a bunch of witnesses who took the opportunity to describe harassment and distress that they felt from third parties, both on social media and otherwise. No third party, including any blogger, any social media personality, any member of the public, no third party speaks for Ms. Reed. No third party speaks for the defense. No third party acts on behalf of Ms. Reed, is directed by Ms. Reed or the defense, or is under Ms. Reed or the defense's control. None. There were very obviously vile acts that were described during the course of the first trial in these witnesses' testimony. To the extent that they did occur, they are obviously in no way condoned by the defense, by Ms. Reed, or anybody connected with the defense in this case. And they're in no way connected to Ms. Reed or the defense. And notwithstanding that, the witnesses strongly suggested that Ms. Reed and the defense itself were somehow responsible for these alleged and very reprehensible things that they were describing. In one notable instance, Jennifer McCabe recounted being harassed by a blogger. She didn't name the blogger, but she said, quote, "The defense is very familiar with this person," end quote. That was her trial testimony, and she looked right at the jurors when she said it. The very obvious overture was, "You know who this is, Mr. Jackson. I was the one cross-examining her, and you're responsible for it." In some way, shape, form, or fashion. She outright suggested to the jury that Ms. Reed and the defense were responsible for the acts that she went on to describe in great detail, in which we agreed, if they occurred, are vile, reprehensible, unacceptable. There are clearly, as we all know now, there are clearly people out there who are very deeply concerned about what they consider, the others, consider an unjust prosecution of an innocent person for a crime that she did not commit. There is an enormous amount of emotion injected throughout the community, this community and beyond, and we don't control that. And if people have suffered as a result of that, Ms. Reed very specifically should not be the one to have to bear that burden, and she did in the first trial. Those individuals out there who are emotional about the case, who are a proponent of one side or the other, they speak for themselves, they act for themselves, they act on their own accord. They certainly don't act at the direction of the defense or of Ms. Reed. And to allow these sort of what ultimately can only be described as salacious anecdotes into evidence, coupled with the sobbing and the crying and the breaking down on the witness stand, which also happened. It serves to visit an extreme and an extraordinary prejudice against Miss Reed, very, very specifically and very targeted like a laser on her. And it's for conduct that's completely out of her control and completely unassociated with her. What may be most galling about the Commonwealth's presentation of this evidence in the first trial of witness intimidation was that they were in possession. They actually knew. Mr. Lally, Ms. McLaughlin, they knew at the time the information was presented and propounded in front of the jury that a grand jury had been impaneled to hear evidence on whether or not Ms. Reed was in any way liable for witness intimidation, witness harassment, or anything associated with that.
So the grand jury has a particular standard, right? Not any way, right? Probable
I
cause
understand
standard,
that.
right? Okay.
But notwithstanding that standard, the question was she in any way liable for that harassment and intimidation? And that standard is extremely low. We all know the ham sandwich anecdote. And even the grand jury said, no, there is absolutely nothing to see here. There is no evidence that she was responsible for intimidation or harassment such that they determined that there was a no bill. And what is bothersome is that the Commonwealth was aware of that and didn't disclose it. We didn't find out about that until in October. I think it was an October notice of discovery when we finally found out that a no bill was issued indicating that Ms. Reed.
When was that no bill issued?
You said when or where?
When?
When? I want to say March 23rd, March 27 is what I'm being told. It was late March, before the first trial. And they knew this, and they didn't provide what I believe, and I think what the court would have ruled would be exculpatory information to us to cross-examine these witnesses who say, hey, look, I've suffered at the hands of the community, of these bloggers.
So my memory is I kept it out, and then I have a very clear memory of you opening the door with Jennifer McCabe, and it came in through there.
So the court did make that ruling that ultimately, if the door is open, these witnesses are going to be able to talk about it.
But I kept it out prior to that.
Understood.
Okay.
I don't want to revisit that issue. The court made its ruling. I didn't think that we had opened the door. It was whatever that door was. It was on some very, very significant lubricant. It was going to be opened very easily.
Read the transcript.
I have several times. In any event, I believe that the court should make the exact same order this time and have a more defined, we should have a more defined understanding of what would reasonably open that door. I didn't think that I came anywhere close to it. The court disagreed and the information came in. But it's so prejudicial. It was so extremely prejudicial as to Miss Reed that I think we need to revisit that issue and get a more clarifying order about exactly what would be required to open that door. And then we can reasonably, as the defense, we can reasonably sidestep that as best we can. I wasn't able to do that in the first trial because I didn't think that I had even approached the line, but ultimately the court disagreed. So what we're asking in this instance is that we get a clarifying order that it is not admissible. Obviously, if we walk in and say something about witness intimidation, you've never been intimidated by anybody, have you? Obviously, that would open the door. That's not what would happen. That's not what happened last time. What happened last time was Jennifer McCabe basically decided that she wanted to talk about that issue and sort of walked through it, at least in my view, having reviewed the transcript. In any event, I think the court understands what our concern is with regard to this subject matter. We don't want a free-for-all of people, one person after another walking into court and basically lambasting the defense for all intents and purposes about things that are completely out of our control. Even if there is some suffering by the public or by bloggers or by whomever that these witnesses have had to undergo, that is not at the hands of the defense, and we shouldn't have to, Ms. Reed very specifically, should not have to suffer through that testimony when it looks very, very clear that at least the Commonwealth wants the jurors to believe this is all at the hands of Ms. Reed, that she's been the one engaging in this, which is, or the defense has, which is just not true. So we would
Okay.
ask for a clarifying order on that issue very specifically.
Mr. Brennan.
I can appreciate the defense wanting to identify the line in which they would open the door to evidence about harassment and abuse of witnesses. I understand why that would be important. But to convert that into a speech that absolutely defies reality and grossly misstates the history and facts of this case is beyond me, It wasn't just last night when Attorney Jackson and his colleagues appeared on a documentary where Ms. Reed talked about speaking frequently to Mr. Carney, sharing anything public with him. And you would have to choose to be oblivious to think that that information that is shared was then not generated to intimidate and harass witnesses for 2 years. In fact, Mr. Carney has over a dozen indictments for just that. You've had an opportunity to hear the conversations recorded with Gretchen Voss. You've heard about the tactics used by the defense in the dissemination, not just of public information. So to try to make a public record that is so grossly, not only inept, but fraudulent, I don't understand the purpose of that when the simple question is, what is the threshold of opening a door? We have a motion later this afternoon in another courtroom on this very issue. And I'm not going to go through an entire resuscitation of the evidence or information that I have, because that inevitably would be unfair. But it is unfair to stand up here at this podium and suggest for a second that Ms. McCabe is using a witness box as some type of forum. She didn't drag herself into this case. She was dragged into it. And to suggest they can stand here and bash witnesses in the text of their argument, unsolicited attacks, because it pleases them and fits their narrative, is something I can't just sit by and listen to. The Commonwealth, the prosecutors weren't outside patting their bloggers on the butt for a job well done after witnesses were harassed at the family events. That didn't happen. And so if the issue is, what is the threshold when Mr. Jackson opened the door? Well, you can read the transcript. It's very obvious. Open-ended questions, personal attacks, baseless accusations. That opens the door. And it will open the door again, I suspect. And we'll be prepared. I think the issue is really a trial issue, and an attorney having control of their questions so they don't open the door. That really is the issue.
So do you agree it doesn't come in the Commonwealth's case in chief with these witnesses?
I don't think it ever should have come in the case in chief, and I don't think it would have until I saw the very clear questions that opened that door. I have no intention of raising a collateral issue or trying to present prior bad acts that I haven't sought admissibility for. So I agree. I agree.
Okay.
Your Honor, if I may very briefly.
Sure, just give me 1 second. I want to take one note, okay?
Of course.
All right, go ahead, Mr. Jackson.
I just wonder if where this ire and these invectives from Mr. Brennan come from. He said that I stood up here just a second ago and attacked witnesses and bashed witnesses and made fraudulent statements. Was he listening? I didn't bash a witness. I didn't attack a witness. I didn't make any fraudulent statements. The Commonwealth made their best effort to tether Miss Reed to Aiden Kearney. And they did it through a grand jury. And those members of the grand jury said, no, it's not true. It didn't happen. That's what they said at the lowest burden known in criminal justice. So Mr. Brennan can stand up all he wants and say, I saw a TV show and I saw this and I heard an interview, and clearly there's been communication between Ms. Reed and Mr. Kearney. Sure, there may have been communication. That's very different from directing witness intimidation, directing witness harassment for the purposes of undermining a prosecution. That's what they've accused her of, and they failed. And then they kept that from us when they failed and allowed this sort of fabrication of the witness. And I'm not saying that the intimidation that was described on the witness stand was fabricated. That's not at all what I'm saying. Maybe it was true. Maybe it all happened. What was fabricated is that it was connected to Ms. Reed or connected to us. So nobody's up here, Your Honor, and I take issue with Mr. Brennan's tone and tenor. We can all be professional. We can all advocate very zealously and robustly, but let's keep it professional. I didn't stand up here and attack a witness, or what did he say, bash witnesses, use this as an opportunity to bash people. We could calm the drama down just a little bit and probably get a little further. All we're asking is that it not come in, and I will stipulate and agree with Mr. Brennan that this not come in the Commonwealth's case in chief. And we will be very mindful of what would conceivably open a door to this kind of testimony. And I'll probably seek the court's guidance before I ask a specific question that I think comes anywhere close to that. We'll ask the court's guidance by coming to sidebar. And I think that could resolve the issue.
Okay. Thank you. I want to look at this a little more closely. All right, the next one is paper 571, and the Commonwealth's corresponding is your number 12, our paper 586. So the defendant's moving to exclude the serum plasma ethanol concentration, blood ethanol concentration conversion, and corresponding retrograde extrapolation analysis. So who's arguing this for the defense? Because I'm going to ask you whether you want to argue your opposition to it or have the Commonwealth make their argument for admission of it. Who's arguing it for the defense?
Your Honor, I am. And to answer your question, the defense preference would be for the Commonwealth to go first. And we would respond, including with regard to the motion.
Okay. So Mr. Brennan, our paper 386, your number 12.
Your Honor, our paper number 12 seeks to admit the results of the defendant's blood draw at the Good Samaritan Hospital and the resulting serum conversion and retrograde extrapolation. This being a OUI manslaughter and murder case, the statutes that the defense cites don't apply. This is not a simple OUI case. We expect that we will have a witness from the hospital describing the protocol. We will have a witness from the hospital to testify about the blood draw, and we will have an independent, or we'll have an expert to talk about the blood serum conversion. These medical records are admissible. We've cited Chapter 233, Section 79 as a business record. I know the defense takes issue with that. However, these records are routinely admissible. Commonwealth v. Hallinan, 491 Mass, 730, page 736, note 9. Blood alcohol serum conversion and retrograde extrapolation is admissible. While the standards may be different because it happened at a hospital, these are agencies, hospitals are facilities that have standards that comply, that are trustworthy, and this evidence should come in pursuant to those cases in that statute.
All right. Now I'll hear you, Mr. Alessi.
Thank you, Your Honor. Attorney Brennan misstates our position that is clearly set forth in our papers. We are not citing to statutes that discuss consent of Ms. Reed. So I just want to take that because he's conflated issues and not addressed the main issue. Attorney Brennan just said that the results are reliable. And I appreciate very much that he has raised that, because not only is there no proof that the results are reliable, there's proofs in the first trial admissions as by Mr. Roberts, as well as impliedly by Ms. Knowles, that they're not reliable. And here's why. There is no record evidence as to the method of the hospital determining those levels. Specifically, with regard to the medical records in the chemistry section of those, it says in an annotation, the drug testing, this report is intended for use in clinical monitoring and management of patients. And here's the key statement. It is not intended for use in employment-related drug testing or court-related proceedings. And the issue with regard to the reliability of the testing is it is not stated the basics to go to reliability. Specifically, there's no documentation of how the alcohol test result was obtained, through what procedure, by whom, and the key, what manner of testing. There's two ways to do it: gas chromatography and enzymatic testing. And there's a huge difference in the reliability between the two. There is no record evidence, and it's the Commonwealth's burden of proof to establish reliability. There's no evidence of any of those foundational aspects with regard to the testing. So with regard to those test results, the Commonwealth has to establish the reliability. It is not enough for the attorney for the Commonwealth to simply to stand up and ipsy dixit in saying they're reliable when there is a lack of the information of the factors I just rehearsed with regard to the matter. And another key aspect, which is conceded by the Commonwealth, they concede that the testing did not occur at an accredited laboratory. They concede it. And it's in every single report of the Commonwealth. And we put that in Exhibit A to our motion. For example, it's Exhibit A, the very first page, COM 000994, serum plasma conversion report. It states, 2 paragraphs under the chart, with an asterisk, the ethanol result used in this serum plasma conversion report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory, and therefore this report does not fall under the laboratory scope of accreditation. Not the words of the defense.
So that's from the State Police Crime Lab, right?
Pardon me?
That's from the State Police Crime Lab, right?
That's correct. And with regard to the next document, which is our Exhibit B, in terms of changing that conclusion, in that statement. There is nothing in there to remedy that statement. Exhibit C also mentions, and this is NDAO 296, under background, it's the same statement. The ethanol result used in this retrograde extrapolation report was provided by an external party. The testing to obtain the ethanol result was not performed at the Massachusetts State Police Crime Laboratory. So what we have with regard to the foundation of reliability, we don't know what type of test result this third party did, gas, chromatography, or enzymatic, and we don't know any of the other factors, and it's the burden of the Commonwealth to establish the reliability of that testing. So in conclusion, Your Honor, given that the Commonwealth has not satisfied its burden in this regard, the testing that has been performed is not reliable.
All right.
It should be excluded.
Okay. Do you want to respond, Mr. Brennan?
I would suggest the court look to Dr. Fowler's testimony. He testified how blood was taken, how it was preserved, what tests were conducted in the lab at Good Samaritan Hospital, how the lab is accredited. And this is the same issue argued at the first trial, but inevitably Dr. Fowler's testimony is what establishes the foundation for the admissibility.
Okay.
May I just respond briefly?
Sure.
Thank you, Hunter. Your Honor has often said that this is a new trial. The Commonwealth for this trial has to establish that foundation. They can't point to the testimony in another trial to establish it. That should have been in their motion in opposition, that they should have put that in, assuming that that is accurate. But it is not in their motion here, and that cannot be relied upon to defend the lack of reliability with regard to those factors. And I will also note that none of the witnesses I just rehearsed, Mr. Roberts nor Ms. Knowles, if we're going to talk about the first trial, ever referenced that as curative of what they said for lack of accreditation. And if we're again going to go back to testimony of the first trial, Mr. Roberts on cross-examination clearly expressed concerns with regard to these foundational absences with regard to testing. Thank you.
Okay. I think we have time for one last motion before we take the morning recess. Paper number 574, defendant's motion eliminate to exclude witnesses' prior criminal history. Who's arguing that for the defense? Is there no objection to this? This is regarding Richard Green.
It doesn't qualify pursuant to the statute.
All right, that was my question to you. How do you expect to get it in?
I don't.
Okay. All right, so this motion is allowed. That's 574 is allowed, Mr. Clerk. All right, so what I'll do is I'll see counsel at sidebar regarding scheduling.
Good morning, Matt.
Good morning.
Morning. Regarding scheduling, is this, are we going to, she said a recess, so why are they, I'm just curious. There's more to come today, right? I mean, she said.
Yeah, I think so. I think she's probably just like, are we going to be able to do this in the next 2 days? And which ones are important and which ones, you know, are going to spill over.
So a lot of interesting stuff today. You want to react to any of it?
I mean, I think that, you know, no action on the deliberate misrepresentation of Arca is a little ridiculous. I mean, it's really weak. Like no action whatsoever. Like maybe don't take that pro hoc vice away, but like nothing. Like, is she a joke? I mean, she's just so weak. It's like pathetic. It really is. And I mean, I think I know that a lot of people go after her about being pro prosecution, and that's so not true. She is so pro defense. She was a defense attorney. So it's kind of like, I don't know. I just think it was actually ridiculous. Like she could exclude them. She could do something. But she did nothing. So they were
I
all
think her
smiles.
options. I think her options were very limited. There will be sanctions imposed after the trial. I just think that at this point, it would be a very unlikely decision for her to take off any of these attorneys because it would result in a very long postponement of the trial. And she doesn't want to do that. And as we've seen in other cases, so for instance, in the Richard Allen trial, the judge removed his counsels because of the leaking of the crime scene photos of the girls' bodies. That's a pretty egregious offense. And so that's, that she had good cause to remove them. But I watched that Supreme that SJC hearing when the
Didn't Karen leak crime scene photos though, like to Turtle Boy,
yeah, which is different, but yeah. So there's just when you watch that hearing, it really is compelling that these states are not going to want to take away the preferred lawyers of a defense counsel of a defendant for murder, and so I just never thought that was going to be the solution here, and I don't think Hank thought it was either or wanted that. I think his goal was a long game, and what he's trying to do ultimately, and this hasn't been decided yet, and I think the judge is going to do this, though. She's, again, going to not allow mention of the federal investigation, and this time she's not going to allow the defense to portray Arca as independent. I'm not a lawyer, so I could be wrong, but that I've been predicting for a few months that that's what the real game was afoot, and if it was, I think it's well played by Hank Brennan,
I mean, I just think the judge is just not changing enough things. Like if you look at like the Menendez trial, like how drastically that changed between the two, because the judge saw I made all these mistakes. That's why it was a mistrial. Right. And not that I'm on a certain side of that, but just saying like in this case, she's just so weak. She's not really holding them accountable for all the stuff they've done. They lied throughout the entire thing, had this media circus, and she let all the witnesses get harassed. She is like the worst judge I've ever seen.
Was Hank Brennan a little bit surprisingly understated there in his response to about the witness intimidation stuff? I thought he was really going to lay out some evidence there because they have so much direct evidence of this. And the fact that a grand jury didn't indict is not like Alan Jackson is trying to imply, meaning that it clears her. Not at all, So
I feel like he, in some of these cases, he's just trying to get them to like commit to something on the record. So that when it does come down to it, I mean, I think he's going to get it in. I'm pretty sure. He's just saying it's not part of like the case in chief, which means he's not going to bring it up in opening and closing. But I'm sure that he's going to get in through the witnesses.
Yeah, because they already mentioned in a motion last week that they want to get in evidence from Cosgrove. So regarding Turtle Boy, in order to introduce Karen's consciousness of guilt. So I was kind of surprised that didn't get brought up here. Maybe that's going to obviously it's going to get brought up later in that motion, but it almost seems to contradict what he was saying there. Like, we don't intend to bring this up. So,
yeah. And then the Aruba's not getting brought up. Like that's strange.
Yeah. I didn't think, I thought that was going to be the case. And I think it's a good idea, but people will disagree on that, but I think it's better to streamline this case and stick to the fundamental evidence. Oh, they're going to break so we can stay on.
You are muted.
I don't know. And I mean, it's just like the documentary that she like. Karen is the dumbest defendant I've ever seen in my life. Like she could have easily skated by on this. Like it even gotten like a very light sentence. But she decided to create a circus because she's a narcissist. And like that documentary didn't do any favors. She looks like an idiot.
No, it hasn't yet. We'll see where it ultimately goes. I have not. Have you seen a whole? Did you get a preview for the whole episode?
No,
I
haven't seen the whole thing, but it's just, and I feel like it's pro Karen. Like if you think about like the facts, like they're not laying out a lot of the evidence yet. So it is pro Karen, but she is just so unlikable. She makes my skin crawl. Like you can just tell she's lying. She changes the story every 5 minutes. She has no remorse. She's just a disgusting human being. And like that's what's going to do her in more than the evidence and more than what she did in this case. It's like that she is stomping all over the victim's family. She's gross.
Did you take any new evidence or insights from the documentary last night?
I mean, the glass in his nose, like that was like shocking because okay, now we know he didn't get in a fight, right? Unless
Why would
like
she say- I'm still baffled because I don't think she's an idiot. She's not an idiot.
I think
So
she
there
is
must
an
be some
idiot.
I mean, there must be some reason that she mentioned that, but I can't speculate at this point on why. You know, is there some new evidence that's coming out? I don't know. Because if you get in a fight in the house, you're not going to end up with glass in your nose.
I know. Do
You
police
know?
officers in Boston throw glasses at each other? Is that how they fight in Boston? Like,
I've
what
been
is
in
she
the middle
talking
of
about?
1,000 fights, and I'm not even exaggerating because that was my job. And I've had bottles thrown at me, but I've never been in the middle of a fight. I've been around plenty of broken glass in some of the big brawls, but I've never seen a piece of shard end up in somebody's face. So I don't really
Right.
understand why she was even telling it. But there's probably some reason though. You know,
That happens in car accidents, though.
yeah, exactly, and especially I would think that if it is a true story on account of the glass being there, John's got the cocktail glass in his hand, and that hand snaps into the back of the car on the panel, leaving that dent, and the car is a 6,000-pound vehicle going 24 miles an hour. So that doesn't surprise me that once it smashes that glass, some of those pieces are
Mhm.
airborne and they might stick in his face. So it really seems strange to me that she mentioned that.
Yeah, it must have been before the medical examiner's testimony. She might have thought that the
really?
injury was going to
Yeah.
get brought up, you know?
Excellent point. That's excellent point because
She didn't realize how bad
yeah.
Scorty Bello was going to be. Because Scorty Bello, it was a joke. Like, she shouldn't
and
even
it was
have
the
her job.
And the criminologist talked about the glass too. You know what? I think you're onto something, Matt, because Kate's here too. Let me bring in Kate. Good morning, Kate.
Good morning. Sorry, I had to chime in because so I was discussing this glass piece in the nose revelation, accusation, whatever, with someone who was on the scene that day. I'll put it that way, right? Civilian.
Yeah.
And I was told that was a lie, that never happened, right? And if you think about it, it was freezing, and she's saying that he's gushing blood, and that's usually, you know, your blood's probably pretty coagulated, particularly with the cold. So I don't know if maybe.
Not to mention that his heart didn't. I think you have your speaker on, Kate.
Oh, sorry.
Not to mention that his heart wasn't beating. So I don't know, but I wouldn't say that it's impossible that blood couldn't come out. You'd have to have a doctor talk about it. But I think Matt is onto something here, that maybe she, I don't know. This would have been recorded presumably in April, and at that point she should have had the glass testimony. But did she think that there was, for instance, I don't think they found. You know what? They found a piece of DNA. It was found on the cocktail glass, right? Not on the piece of glass. Where was John's DNA found?
I don't even remember.
I think it was found on the glass.
On the glass
possibly
itself, as I thought.
I think what I interpreted that is that he had, drank from the glass, which she has now taken responsibility for too.
Right. The full glass of her vodka soda sitting in her cup holder. Like, what in the hell is she talking about? She is the dumbest person I've ever. I don't even understand.
I have to agree. I'm sorry. I know that she's touted as being very intellectual. She's clearly educated. I'm not going to take away from that. But as far as like actual common sense, intelligence, self-preservation, zero, zip, nada.
Well, I think one thing with the glass could be this. Now, obviously, we can see on the waterfall video that it's John that walks out with the glass. But John is a Bud Light drinker. So it makes sense to me that he was walking out with Karen's drink. Maybe she didn't want to finish it, but she could potentially use that to say that crosses one of the drinks off the list. Like, all right, yes, I ordered that drink, but I didn't drink it.
And I think honestly, like if you read the report, and maybe I'm reading into this too much, but they describe the glass that she's drinking out of as a vase style. I believe she described that as well. And he's got a lowball glass in his hand when he leaves. And I believe I'm 90% certain that they describe it as being like half full or less than half full, like it's not full. So like yet again, just another inexplicable apparent lie that Karen has told that doesn't help her at all. It just connects more to the crime scene.
I feel like there might be two glasses though, because wasn't the black straw like a tall straw that would be in a tall glass? It wasn't a rocks straw, like the little straw.
Yeah, I don't.
So it didn't matter.
I don't think it was a rocks glass. It was like what we used to call a 14-ounce or 12-ounce pint glass. That's what it looked like to me. I don't know. I'm not sure, but it could have been a rocks glass because from looking at the trial, the base of the glass matches the base of a rocks glass. So Kate could be right on that. I remember looking that up in the trial. They listed in the inches. What was it, 5 inches or 5.5 inches? The base of the. I don't remember. I could be wrong on them, but they did list that. And at the time, I looked it up and like that. Yeah, that matches a rocks glass. So Kate could be right on that.
I have to jump, but I'll be back on in a little bit.
Thank you, Matt. So I myself with. I don't believe that she ever says anything without some purpose. Now, that purpose may look odd now because the evidence that comes, like Matt said, this was recorded before the first trial. So, for example, all the way back when Gretchen Voss was interviewing Karen, and that's in July of 2023, Karen strangely tells a story with all three of her lawyers present that the what was I saying? Oh, I'm sorry. That the taillight was missing pieces. In fact, it was missing pieces badly. She was afraid that it was going to affect the functionality of the car. She could see wires and stuff like that, and that she even pulled the piece out. So, why would you tell this story if you later on know that you want to say that your taillight was only cracked and not missing pieces? It was very strange, but it's obviously they hadn't figured that out at that early time. So, what she was telling that story was I believe that she was trying to suggest that she pulled that piece out, dropped it in the driveway, and then when the state police didn't find it, when they searched it a few days later, they must be lying because she knows there was a glass piece there that was dropped there.
They took the pieces from the driveway and then planted them. I think that part of her problem is that she's trying to cover for so much evidence that she's losing track. I was just informed actually that there are some free Karen Reed people that are still trying to claim that the drinking glass came from in the house. So I guess she's fortunate that her supporters will bend logic for her, because again, like that to me was shocking for her to. I mean, you are literally connecting yourself to a piece of physical evidence found at that crime scene, right?
Yeah. And if it was in the house, why bring it outside?
Why have a straw? Like a bar straw, right?
I could see if you had a straw, but why would? How did that drink end up outside? If John was if that glass was from the inside of the house, and John was beat up inside the house and then later dragged outside, why would they throw the glass from inside the house, which would match him to the crime scene? I mean, that's absurd. You know, even if you want to go with the theory that John got beat up, what would make more sense is that, especially given that we know that he left the waterfall with a glass, is that he went into the house, got beat up, and then later on, they were the real killers figured they better put the glass outside with him.
Okay, but there's option C here. Sorry, but there's option C here, which is just say nothing, right? Like, I mean, if the Commonwealth can prove that the glass came from the bar, make them prove it. Don't connect those dots for them on a nationally televised freaking tell-all documentary. I mean, it's just like this is retarded behavior. The same thing with she acknowledged that she was using, not only that she was using Natalie, although not by name, but she was using an intermediary to talk to Turtle Boy, but then goes a step further and goes, at some point I got nervous about the intermediary, so I just cut her out. Like, what were you nervous about, Karen? Again, like, can they prove that they've been talking? Yeah, they can. Make them do it. Don't do it for them. I mean, this is just like, I don't think she's very smart. I don't.
So Hank Brennan mentioned a court hearing later. This is the Turtle Boy hearing, I assume?
At noon, I think he's getting. What do you mean the Turtle Boy hearing?
Well, he mentioned an unrelated. I don't know. I don't want to quote it. Let me see if I wrote it down. But he mentioned. I don't. Again, I wish I had the quote. Another hearing later this afternoon, and as though it had some relevance here. I'm sorry. He said a motion in another courtroom is what he said.
Right. So that's they're constant. It's weird what they're trying to do, and I kind of chuckled sardonically about you know, they get this entire sort of reprimand, not sort of, a pretty strong reprimand about candor to the court at the top of the hearing, right? I was like, I bet they already have lies pre-written for today. And then they go in to this third party culprit thing, right? And they simultaneously want to completely distance themselves from Aiden Carney and claim we have no control over this. This has no input on this. This is not us. But then at the same time, they want to double back and continue to wink to this cooperative defense that they on paper say doesn't exist, right?
Right.
Like, it's just so
they want,
dishonest.
and they want to call him vile. I did notice that, but or what happened they described as vile, and they had no connection to it. But I thought it was just stunning too for Alan Jackson to actually tell a judge that the fact that a grand jury did not indict Karen is equated to clearing her of any involvement with Turtle Boy or any involvement with any of this stuff, even though plenty of they know evidence was submitted for that. It's just because a jury fails to indict somebody does not mean that that's not proof of innocence. It just wasn't enough.
There's probable cause enough to get a warrant. Okay. That is clearly still under investigation, and clearly there's information that's still coming out. Like that's, I mean, just from March, last March when they did that grand jury to now, they still haven't gotten into Turtle Boy's phone. They're still playing the kick the can down the road games. Sorry, that and that is as of yesterday. They're still delaying the taint team search, and then every once in a while Turtle Boy will go up and cry about how they still haven't gotten into my phone, like because he's delaying it, right? So like I don't, it's not a good argument in the sense that like this isn't over. Now, whether the timing, particularly with these delay games being played with the phone, works out for this trial, I don't know. It would be a lot better if they hadn't brought it to grand jury and it hadn't come back with no bill, right? But it was probably a short-sighted tactical error on the part of a special prosecutor Mello. But like, it doesn't really change anything. There is a ton of evidence, and again, like they're looking really at the grand jury, and they're ignoring the fact that a judge signed off on a warrant. There was probable cause that she's involved in criminal behavior. Right.
It's just amazing to hear this talked about openly in court. It was, so I mean, does the defense have a point of it? Was a little. It seemed like the door being open to talking about that witness intimidation. The judge was quick to open that door, but I think that just reflects the practical reality that she understands what's going on here. But from a legal standpoint, was it a little bit quick? Maybe.
I don't know. I mean, a good solution to that is not engaging in the conspiracy to intimidate and harass every single witness, investigator, prosecutor, and judge involved in your prosecution. So I would say that's a self-made problem right there, and they opened the door.
I was a little disappointed. There was such an opportunity, and I'm not criticizing because I'm not a lawyer, but I thought there was an opportunity for Hank Brennan to go into much more detail on that. I thought he might even mention how Yannetti had gone to the parking lot where Courtney Proctor was working. I mean, I don't know which of these things are legally allowable because that's not necessarily proof of something, but it did happen. Yannetti doesn't deny it. And then all the communications between Turtle Boy and the attorneys and Karen, you can't just completely, Hank did try to say you can't just be naive and distance yourself from that when clearly it's happening. But,
I would have brought up the warrant. Again, probable cause exists somewhere right here on paper, right? So there's probable cause that she was involved when we're talking about the lowest possible legal standard. There you go, right?
Yeah.
I don't know, but I'm not a lawyer either. I'm just a mid-grade idiot.
Did you notice last night, Karen, this stuck out to me, looking right at the camera and saying to Jen, basically, one of us is going to win here.
Yeah, it was psychotic. It just shows that she set up that dichotomy. I was there, Jen was there. It's either her or me.
Yeah. She said, either I'm going down or you are. She doesn't say she says you are. So she's addressing her directly, turning it into this like alpha female contest, which is really, really bizarre, but does kind of confirm, I don't know if you heard me saying it earlier, Turtle Boy, when he said that when he went to the lacrosse game, when he made those strange statements to Jen McCabe in the stands saying, did you think you could outsmart Karen Reed? He later said in his admin chat that it was Karen's was the one that told him to say that to her. It seemed a little weird, but now it seems kind of confirmed. That is how Karen looks at this, right?
I never thought it sounded weird. I thought it was completely plausible. The context in which he was making those statements, where he was making those statements, I think lend a lot of credence to him telling the truth. You know what I mean? Because it was a self-serving statement in one respect, but it's also damaging. I don't think many people are going to threaten to turn somebody else in for conspiracy where that would result in another crime for themselves, unless there was some validity to it. And it just always tracked, because you can tell she thinks that she's the smartest person in the room. This is a game. This is a competition. This is a job to her. I mean, she completely lacks empathy. She's devoid of all empathy. She's a little bit psychotic in that sense.
Yeah. After Judge Cannone this morning really laid into Alan Jackson and the defense being uncandid, misrepresenting facts, even in sidebar, but when she didn't remove them, Karen was up there smirking and smiling like she just won a big victory. Even Alan Jackson understood to look grave, because he had just been really hit pretty hard, but she didn't know any better. She's just up there smiling away like all cocky.
I mean, again, that sidebar was sealed, so we don't know for sure, but I would probably bet the farm on that colloquy being related to waiving appeal, at least on that particular issue for ineffective counsel. So it's not a win. You gave something up, Karen, and a potentially pretty big something. So
right. So I mean, I don't know if you agree with me. So I've been predicting that this is where this was going, but ultimately the goal, and we won't know this until the judge makes these rulings closer to the trial. But she's going to say, I don't know, but she's going to, again, not allow the feds, the mention of the federal investigation. But I think she's going to add to that Arca will not be able to be presented as independent experts. They'll just be presented as normal defense experts. Do you agree with me on that? I'm probably wrong. I'm
it's a given. I mean, I think that, I mean, definitely she made a point that Hank was entitled to a full cross-examination. I don't think she's going to restrain the Commonwealth very much on that. They can't be presented as completely independent, unbiased experts, because they're not.
Right.
Just point. That's not the truth. So,
but they were presented that way last time in the argument that
because nobody knew, and then Hank got it out, right? Nobody knew.
Yeah, but what the defense would say is this: that at the time they made their report on February 13th of last year, that at that time they had no communication with the defense, and they still had the same conclusion. So therefore, it was independent. But what Hank made stunningly clear in that motion that we read on the channel yesterday is that he's questioning, and for good reason, as good faith argument, as he said, the fact that the feds or the U.S. Attorney's Office at that time was in itself independent. And so therefore, kind of like a fruit of the poisonous tree thing, if the U.S. Attorney's Office is not truly independent here in their actions, then likewise the experts they hire are not going to be independent.
Yeah, no, I can see that.
Interesting to see. So you were mentioning this morning about doxing of a juror, and you want to comment on it at all? I haven't seen anything on this yet.
Yeah, I think it's absolutely ridiculous, but apparently I was alerted that the jury foreman's full name and some biographical information was released by Turtle Boy yesterday. Looks like in retribution for the Commonwealth's motion to expand the buffer zone. He seems to be blaming the foreman who, he was his name and identity was also impounded off those court documents that were filed, the motions. But apparently we don't respect that court order either. The guy's just such a menace. I don't understand why he's still in that courtroom, around walking free in society at this point. He's becoming a real threat to the integrity of the judicial process, particularly in this case, but potentially really spiderweb out.
I want to respond to, I'm putting this comment up here for a second before I put this guy in timeout. So I don't know who this is. NCSHP retired. So some kind of retired. He says, Plevin, I was a state trooper for 30 years, investigated thousands of crashes. I cannot today, but would enjoy coming on your panel, me and you, and discuss the crash investigation. Bring it on. Well, I may be willing to do that, and you can email me. But stop being a piece of shit. If you want to talk to me respectfully, don't say Plevin, say Kevin, and don't say bring it on. So, state trooper, 30 years, investigate thousands of crashes. I don't know. Listen, the one thing that this case has taught us, Mr. Retired State Trooper, is that there's no shortage of insane former police officers and former law enforcement people that insert themselves into these cases for some kind of reason, whether they're trying to get some. So he's saying, I can't do it today. So here is probably someone who we can guess is trying to get himself on court TV, trying to get himself maybe picked in other cases, maybe won't be surprised next week this guy will have his own YouTube channel. And because he's claiming to be retired state trooper, he'll probably shoot up to 20,000 subscribers pretty quickly. But again, you're being disrespectful and you have no reason to be that way. So as far as I'm concerned, you're a piece of shit. Now I'm going to put you in timeout instead of, well, actually I can't because he's on somebody else's channel. He's either on Matt's or yours. He's commenting on YouTube.
I'm not streaming it. Yeah. But it's probably not actually a retired state trooper, just to be fair. I see that there's a stock photo of a cruiser there, which is a pretty good indication that this is just another resident of Delulu Island. There's a lot of them a lot of astronaut, physicists, doctor, police, troopers out there now.
I got this guy that emailed me the first time after the first trial, and his name is Walter. I'll just give you that much. And, he sounded respectful at first, and he said, I haven't followed this case. I'm not on anybody's side. I just, the Arca testimony was impressive to me, and I don't. He said he described himself as some kind of engineer, and he said, I believe that is reasonable doubt. But pretty quickly, I was just, people that are like that I'm respectful to. But over the period of weeks, I learned that he was lying to me. Now, I don't know way of knowing if he actually is an engineer, but his conversation, his emails that still keep coming, and I mostly delete them, became more and more agitated and insane. And it was clear that he had these powerful emotional opinions about Karen that had to go back long before. So he's a turtle rider. He's a free Karen Reed person that is pretending to be someone that was objective and probably pretending to be an engineer. And he's completely irrational. So yeah, these guys do come out of the woodwork and you don't really know what they are, what they really are,
Sorry. Yeah, no, the thing is that on the internet, you can pretend to be anything you want. You can pretend to be a retired state trooper. You can pretend to be a 20-year-old woman with an AI picture, even if you're a 51-year-old sexual deviant. So yeah, I take everything with a grain of salt, especially people who claim to be experts, because I mean, again, and this is more for my channel, but I always kind of view skeptically, if you're so intellectual and qualified, you're such an expert, what are you doing hanging around here? That's how I feel about it most of the time. So
right. I don't know. Someone said, answer my allegations. You guys think, I don't know what it is about people that don't understand basic fundamental processes in the world. Somebody thinks that I am talking to you and literally reading every single thing in chat. So he or she said, answer my allegations. What? People make stupid allegations about me all the time. That I'm faking cancer and this and that. So it's just crazy.
I just want to give a shout out to I read a lot of the comments, and what seems to be an old school masshold troll mafia moment is we already have a retired doctor police trooper account in the chat. That was the quickest sock account fire up ever, and I love it. But
yeah. I'm just, the thing is you don't have to be an accident reconstructionist to understand that the evidence here is not the kind of thing. Kevin, answer my random comment in chat. Take a look at chat and see how fast it's scrolling. do you really think I'm seeing every comment? I mean, are you that insane? And if you're insane enough to think that, then maybe I shouldn't waste my time with you, right? So, I mean, I'm trying to glance at chat and see certain things, but there's only so much you can see when it's rolling that fast like that, you know. Oh, so Kate, you had something you wanted to add on the glass thing. Did you already address that, or?
I did, yeah. Just that I was told that that might be falsehood. Who knows? Again, like, you know, that was obviously a frantic moment. So,
Yeah.
I think either way, it's an odd detail to throw in there. Like, you didn't
Right.
have to, you didn't have to volunteer that. The same thing with like admitting to how much she drank. But again, like, she's trying to cover for a lot of evidence. So I guess once you start talking, it can become quite the quagmire really
Yeah.
quickly, right? Because, you know, you want to cover for how much you drank, but you have to account for drinking some because you're on camera. And also you have to explain why you were so fucked up in the morning that you couldn't determine whether or not you actually hit him. And you thought for several days that you might have. And then, oh my God, no, it was somebody else. Like, that's just a lot of, you know, you have to explain why he was found, where he was found, how all the taillight pieces showed up, how broken your taillight was, because you have to acknowledge that, yeah, it was broken because she told a bunch of people about it and showed people, but you don't want to say it's too broken because you still have to say that the pieces were planted. It's just like it's a situation where I almost wonder if her attorneys, did they make her sign like a waiver or something? Like, we're not telling you to do it, but then again, probably not, because they're like involved in it. But it's just such a like catastrophically terrible idea. And I know that I think people follow the narrative of these things and feel like, oh, well, they're giving air to her conspiracy theories, therefore this is good for her. But it's not. It's a lot like the Phelps situation, right? To where like they're going to introduce the controversy in the case for viewers, but like the evidence is going to lead where it is. And then in the middle of it, now you have this, you know, withered freaking vodka hag just running her mouth about intimate details of her case right before her trial. It's just such a catastrophically terrible idea. I understand why she's upset about it, but she can't blame Terry. She can only blame herself.
Right. And she supposedly hasn't even seen it yet either. So, I mean, I don't think last night did too much damage to Karen. So I think, and I wouldn't expect it to either, because like you just said,
you should you should search the hashtag "a body on the snow" on Twitter. It's done a lot of damage to her public perception, right? Because like, again, like her statements are so contradictory and shocking and detailed and fly in the face of this conspiracy that she's trying to build. I think it was pretty catastrophic. And not only that, but like
I think it will be, Kate. But just to finish what I was trying to say, I don't believe. I think at the end it will be after we judge the 5-part episode. But in the early parts, the idea is to build intrigue. So if you were going to, and I'm not even saying I have no idea where it ends up, but just hypothetically, if you're going to come out and say, yeah, this is this trial here, Karen Reed, and it's an ordinary hit and run. She accuses something else and she stirred up a mob, but it's really just a hit and run. You're not going to let that out at the beginning because you want to create that intrigue. So I'm not surprised that it did. I personally don't think it did a lot of damage to her, but it wasn't in the early episodes, but it really would have been a mistake for them to do it that way. You know, you want to build the intrigue. I'm sorry, go ahead.
I think that right off the rip, it was pretty damaging, honestly. There's no good can come of this. And I'm sure, like, as you're saying, like, I mean, would you say that what's been released so far is good for her?
I don't think it really moved the needle one way or the other in terms of jury pool contamination or the public or any of that stuff. I think, you know, it really just sets up the story. So it depends on where it's going to go for there. There are people that have followed it so closely that realized, oh, that's kind of a changing part of the story. That's a new addition to the story. But the regular people in the public wouldn't know that. So they wouldn't pick that up. I thought it was interesting that Yannetti seems to have changed his stance yet again on Steve Scalin to reflect a little bit more accurately, saying that Steve Scalin didn't actually give him any information and didn't have any information, that he was, only had theories. Go ahead.
So if you search the hashtag "body in the snow" on Twitter, if I just read off some of the first ones that pop up for me, right?
Okay. Yeah, good.
Watching a body in the snow and I can't contain myself. Angry face, pained face. That bitch. Hashtag Karen Reed. Here's another one. Did that woman just mock the mother about her dead son? Jesus. Karen Reed can't behave like a normal person, and it's never been more apparent than right now that something is fundamentally wrong with her.
Right.
Has Karen Reed ever come out and told her fans to lay off John's family when taunting them when coming into the courtroom?
Right.
Worrying about what shoes you're wearing and being on TV when you're being arrested for second-degree burning is interesting. Like, I mean, these are new people. These are people that have, like, somebody else says that's just wrong to be booing John's family as they walk in the courthouse. Somebody new, completely, I've never seen this guy before, goes, when the reporter asks, so you didn't kill him? I would have, hell no, and don't ask me again. You got me fucked up right away. Her lawyer ended up having to say, no, she didn't do it for her. I mean, like, this is not good for her.
So why do you think Alan Jackson, I think we maybe mentioned this the other night, but why did he choose Terry? And also, why didn't they have, maybe could they have had something contractual where they said you can't release this documentary until after the jury decides?
I think they're just full of hubris and narcissism, honestly. I think they thought they had an acquittal.
Yeah.
I think that they did this thinking that this would just elevate her post trial. I wouldn't be so, and I'm sure that like the time frame that they probably originally agreed to, if they got an acquittal, the trial would have been, over for quite a while now. And this would have brought her back into the public focus. Because I think that Karen Reed's end goal here, although I'm sure acquittal is on the list, is probably even slightly below fame. Right? She wants to be famous. And I think that to people as vapid and narcissistic and short-sighted as she and her, or at least some of her legal defense team seem to be, all press is good press, right? It's sort of like OJ coming out and writing "If I Did It," because the spotlight starts to fade, right? I don't think she wanted that spotlight to fade. And I think, unfortunately for her, her plan for acquittal just didn't work out the way that she intended it to. And now it's off and rolling. And I would assume, I mean, we know because she confirmed. I know Terry tried to gloss it over and was the consummate professional or whatever, but Karen is confirmed. They're pissed off at Terry. That relationship broke down. And I know that it broke down well ahead of the release. I'll put it that way. So, I think that could have possibly been one of the points of contention is like, well, we agreed we're releasing it now and we're releasing it now. But I mean, just in general, like, this is not a good idea. I don't think it helps her at all. And, it looks like already 2 hours into this thing, it's hurting her, like publicly anyway,
Do you think it went down something like this? So I think I don't believe that Karen or the defense team, when they first started going to Turtle Boy, ever anticipated, it looks like we're going to go get on a break soon, but they ever anticipated this mob. But then once it developed, they exploited it. All right, we'll come back to that later.
Yeah.
Thanks, Kate.
All right. So, Mr. Jackson, I'll hear you on that one motion.
Thank you, Your Honor. I appreciate it. It won't take very long. I want to formalize a motion to continue the start of the trial, which is currently set for April 1st. The reason behind the motion to continue is not because of some conflict that the defense has. We ordinarily would be ready to go. However, as the court knows, there's a significant appeal that's currently pending before the First Circuit based on Judge Saylor's opinion that was issued about a week ago. Given the complexion of what we're moving toward trial for, in other words, count 1, count 2, and count 3, we are mounting a defense based on those 3 counts. If the First Circuit, and I've been advised by our appellate counsel to bring this up, and it was something that he feels very strongly about, we all do.
Okay, Mr. Weinberg?
Mr. Weinberg, yes, okay. Martin Weinberg. If in fact the First Circuit were to agree with our appeal and were to take some action on count 1 and count 3, for instance, either dismiss it or take some other action and remand down to the trial court for additional action, that would set the trial into upheaval. If once the jury is sworn, jeopardy attaches. And once jeopardy attaches, if there were to be some action taken on count 1 and count 3, for instance, those counts were to be dismissed, we would then be compelled and impelled to move to dismiss the entirety of the trial at that point, because it's a very different defense on count 2 than it is on count 1, 2, and 3. It's a different jury that we would pick. It's a different strategy that we would employ, and jeopardy will have attached and the entire case would go away. Ergo, we believe the best practice for the court would be to continue the trial for purposes of letting the First Circuit make its determination about count 1 and count 3, and that's the reason for the motion.
All right. Do you have any timeline on that?
I wish I did. I don't. I do have a generalized understanding of some of the briefing schedule, but in terms of the court making its decision, I don't. So we expect to get our brief in today, probably by the end of the day today. I believe the Commonwealth is going, or I believe that whoever it is that is appearing for the Commonwealth, or for the court, I should say, not the Commonwealth, for the court, is due to file their responsive brief, their opposition. I think it's next week. It may be as late as the 26th, I want to say. I'm going by memory, Judge. So it's Monday? Okay. Mr. Schillinger has just indicated, I appreciate that. Did I say your name correctly? Thank you. Just indicated that it's Monday. The opposition is Monday, and then the reply brief would be to you 2 days hence. So the briefing is going to be done in relatively short order. The decision, that's another question.
All right. Thank you very much. Does it make sense for me to hear from Mr. Schillinger directly, or do you want to handle this, Mr. Brennan? Good afternoon. So we do need you to say your name.
Yeah, good morning, Your Honor. Caleb Schillinger.
All right, Mr. Schillinger, I have no idea how this works. So why don't you tell us?
Sure. So as Attorney Jackson mentioned, Your Honor, Judge Saylor issued his decision denying petition for habeas relief last Thursday. The defendant is pursuing a further appeal to the First Circuit. The parties have agreed to an expedited briefing schedule in front of the First Circuit. The defendant filed her brief earlier today in the First Circuit. The respondent's brief is due Monday, the 24th, and then the defendant's reply brief is due Wednesday, the 26th. As Attorney Jackson mentioned, parties are able to control that much in terms of coming up with an expedited briefing schedule. How long it would then take for the appeal to be decided after that is unknown. And the parties don't have the ability, obviously, to dictate that. I think more broadly, Your Honor, in terms of the arguments here, certainly if it were possible to have all of this resolved before moving forward, it would be ideal to know which charges are going to go forward and which won't. At the same time, Commonwealth is obviously strongly opposed to moving the trial. And so, while perhaps unfair to Your Honor, if there is some intermediate ground or additional information that Your Honor would be able to provide, I think that that would be helpful. We could further discuss this issue and come back tomorrow. I would note the motion for a stay that they are going to file, they have indicated, or Attorney Weinberg has indicated to me through email, will be filed with Judge Saylor, not with the First Circuit. So there's no deadline that that motion be filed today, tomorrow, or even Thursday. So this is not a decision that needs to be made immediately, Your Honor.
Okay.
And frankly, the Commonwealth would benefit from additional time to be able to discuss with the victim's family members, and to the extent perhaps the court is able to indicate whether some amount of time is feasible given the jurors' schedules that are coming in, Your Honor's schedule. That would be helpful information to inform this as well.
All right. I appreciate that. So one of the things that we would discuss the final pretrial conference is how long this case is expected to take. So I think the Commonwealth filed or filled out the pretrial conference report a few weeks ago and said 20 trial days, 40. How many trial days do you remember you said, Mr. Brennan? Or what do you think your Commonwealth's case will be?
I don't remember what I put specifically, but I think if we have full trial days,
Yes.
5 days a week, I expect less than a month. I'm shooting for 3.5 weeks.
Okay. Mr. Jackson?
Your Honor,
24, I'm sorry.
our defense obviously is somewhat dependent upon the Commonwealth's presentation, but
Right.
my best estimate would probably be a week and a half, 2 weeks of full trial days for the defense, if I had to sort of throw a dart.
Okay. All right. The big question is jury impanelment. Again, I alluded to all the recent publicity that I think is going to be very problematic in getting a jury. So I'll let both sides talk. That makes sense to me. months and months ago. We got the jury commissioner's office on this to get us the amount of jurors we need starting April 1st. That process will take additional months in order to, if we change the date. So that's very problematic. So I'll hear you all tomorrow on this then.
May we address the court at sidebar on one issue before you leave the bench?
Sure.
So the defense is trying to postpone the trial based on waiting for the appeal to the federal court, the federal circuit court, for the habeas corpus issue involving the jury's supposed decision on counts 1 and 3. Supposedly, they unanimously were for acquittal on those two particular charges. This is not an argument that is likely to find purchase. So I don't know if the judge is going to weigh that. Hey, Matt.
Hey, I missed whatever was going on, but I was reading the chat. So who was that guy that was just speaking?
You know, that's a good question, and I didn't jump out by telling people who it is because I have no idea. He almost seems like a representative from the federal courts. I don't really know who he is.
Oh, my God.
It wasn't introduced. I got his name, but that doesn't help us. He wasn't sitting with the prosecution, so it seems like he's somebody. He wasn't sitting with the defense either, so I don't know. But they're looking at some kind of postponement here, which causes all kinds of issues, as she talks about with the jury empanelment. You've got a long process here to get a huge pool of potential jury members ready for April 1st. So
this is such a joke. Like, look at the O'Keefes. Like, they're like, can we please just be done with this? Like, I'm sick of looking at this ratchet woman's face. Like,
it's so hard to have to. I can't even imagine to have to sit on those benches every day. I couldn't do it.
All right. So we'll
She
see
loves it,
everybody
too.
back here, not tomorrow, but Thursday morning at 9 o'clock.
Oh, it's
That'll be
over?
the time, Mr. Schillinger, to speak with maybe Mr. Weinberg or counsel.
Well, thank you, Your Honor.
Okay, so see you Thursday. All right, thank
Okay.
you, everybody.
All right. So apparently, no hearing tomorrow. The hearing is on Thursday. Oh boy. They don't work around my schedule. I don't know about you, Matt, because I got an important meeting Thursday. I don't know. The meeting's
Thursday, they'll be back. Okay.
Thursday they'll be back to go over some of this stuff, and so man, now it hangs over us the possibility of a postponement.
Goodbye.
But look how happy they are. Like, what? Like, this judge sucks. Like, she really is terrible. And I feel like she's watching all these like law tubers and trying to be so careful not to like step on the defense's toes. She's like the weakest judge I've ever seen. Like,
see, I don't agree with that but I mean, it's so hard for us to tell because we're not lawyers, right? But for me, I think there's always going to be they don't see the prosecution. If they lose the case, it's over because of double jeopardy, so they can't appeal. But when any defendant loses, there are going to be appeals, especially in a murder case. So she's trying to just protect herself in this case from giving them any kind of a basis for appeal. I don't know. Well, Heather is here. Heather is our lawyer, our residence lawyer. Heather, what do you think? Am I making sense on that? That the judge is just being conservative like any judge for that reason? We'll see if Heather gives us an answer in chat. Am I way off, Heather?
is it Heather Ann?
Yeah. We need to get a
She
lawyer
said-
in the room.
She said they know they're not winning this. So, like, they're just pulling out all the stops. I think if that's the lawyer.
Yeah.
Which I think that is true. I think they know. I mean, I think this documentary, they are just trying to like do everything they can to taint the jury pool, to create all these distractions from the facts, because the facts, you know, are indisputable that she killed John O'Keefe, whether she had intent, whether she knew he was there. Like, that's the only question. And
okay, I got an answer for you, Matt, from a lawyer, and I should have been able to figure this out, but I'm not smart enough. So, the guy who spoke, that guy earlier, his name was no, I guess his name doesn't matter. It's some kind of, yeah, I wrote it down somewhere, but it doesn't matter. But anyways, he is a lawyer for the Commonwealth. He's an appellate lawyer. So he is the one that is handling the habeas corpus argument for the state in court. So he's going up against Weinberg. And so that's why he's there to discuss it, to give feedback on that.
Good Lord. I mean, that was always a joke, though. Like, no jury, even the law tubers that are on her side always have said that is a joke. The jury can't just be like, oh, whoa, well, actually, we decided after the fact. Like, imagine if that was the case. Like, every jury could just be like, can we do a do-over after, like, someone's convicted or not convicted? Like, it's the dumbest argument.
And it would just open up such a huge can of worms. I think there's a case to be made that maybe jury deliberations, it should be made more clear to the jury that you have the option of acquitting on certain charges. And I think there's a legitimate philosophical argument for that. But you're not going to get a reversal on this case. The judge didn't err at all, you know, that she was going within the consistent practice of law for 2 centuries in this state. And presumably in other states the same way.
I don't actually think that the jury did acquit her on 2 charges. I mean, I just don't think, like, I just don't believe it. I think that they totally didn't agree with each other, and I think that they just only discussed the main one, whether she did it or not. Yes. Because how are you going to discuss the other ones if you can't even, you know, define whether she hit him or not, right? Then it goes into what was she thinking? Did she have intent? But they couldn't even get past that. So how would they decide on the other ones? Like, it doesn't make any sense.
Right. No, I totally agree. I what I'm saying is not. I agree with you. I don't think that the jury voted to acquit, unlike what some of those jurors are trying to say now. They taking a temperature of the room vote when you first get into deliberations is not the same as actually voting on the charges. Right. It's normal when you're on a jury, when you first get into the room, you're going to do like a little temperature, take the temperature of the room, how people feel about it. So then you can decide where the differences are and you can focus on that. But there was no point in deciding whether or not there was any malicious intent or whether or not Karen left the scene of the accident until all 12 people agree that her Lexus actually struck John, and they never got to that agreement. So, what is the judge going to do there? Is the judge going to, you know, is she going to postpone the trial to wait for this?
Oh my God. It's just such a joke. Like, imagine, like, I don't know. I just think that Karen is like, and now she's doing these things and attacking Peggy O'Keefe in that documentary. She's just such a terrible person. Yeah. They should revoke her bail then. If they're gonna delay the trial, revoke her bail. That's the only way that I think is fair.
Let's, and there's another thing to consider too, is let's say there was a substantial postponement. Let's call it 2 months. Does this benefit the defense or the prosecution?
I mean, I could see ways that Hank could then start arguing to get this documentary into the trial, you know, but it's like, it depends on what, you know, because the documentary just came out. I think this documentary is screwing her, and it's kind of in her favor, but she's so stupid that she doesn't know what to, like, I just don't even understand. It's like the most narcissistic person I've ever seen. Yeah. She's so full of herself, and she has like the turtle cult backing her, cheering her on, that she doesn't realize that normal people see her as a freaking maniac.
And she's going to blame Terry, who supposedly flipped on her, even though all Terry is doing is recording her words and putting them into the documentary. Now, that said, there is a degree of control within a documentary like that, because you got hundreds of hours of footage and you're choosing what to put in there. But did they really expect her to make a like a Richie Keough propaganda film? Is that, you know?
They might have. I mean,
Yeah, get that in writing then, dudes, or make sure you've worked at this. Make sure you've done a documentary with this person before, because this is. I mean, Terry does Unsolved Mysteries. She's the owner of that. This is the first long length documentary series that she's done. So there was no other way they could look at her work and say, oh yeah, she just, if you give her this kind of access, she'll just give you what you want. There was no record for them to base that on,
I think what it is that she's had so much luck with the law tubers because like the likes and clicks and views are for the conspiracy. And so her expectations and her reality is so distorted that she just thought like everyone is a grifter. Everyone is just going to jump on this because it's like the better side of the story and not tell the truth. That's what audience wants and that's what they're going to do. And I think she's so deranged that she really, I don't even know what she thinks. Like she's so full of herself. She has no remorse and she just like has such an attitude. I just don't understand it.
Yeah. I mean, the capacity for the human mind to believe things, we've seen this in many other kinds of situations, not just criminal cases, but there's that cognitive dissonance thing. So when you have something in your head that is causing you a lot of mental anguish, then your brain might come up with other things, and it could be fantasies that lessen that anguish by buying into some false scenario here. And that could have happened here. I think, as I started to say before the break with Kate, I don't think Karen or her team foresaw this circus when they started going to Turtle Boy. Yes, they wanted to get their story out there, but they did not. Nobody could. I don't even think Turtle Boy could have envisioned this kind of circus that came about. But then once it did, they've exploited it, but they've also bought into it. And so at some point during that, when they could see these armies of people out there eventually in pink and say, oh, let's go get a documentary. And for Alan Jackson, he says, here's a chance to turn myself into a star, So it's not about when Jackson, his motive has nothing to do with Karen. It's like, here's my chance to turn I can become the epic star lawyer of this generation, And Karen is, like you saying, buying into her own fantasy that she's this great person out fighting for justice and to reform the system. And pretty soon she's going to be healing the sick and just buying into this fantasy. I don't know. Does that sound plausible?
I mean, so some of the stuff that her family said in the documentary, I was kind of shocked by. Like her brother saying, oh, she wasn't really that sad. And she was just like, Dad, what's the plan? And I'm like, exactly. That is exactly what happened. Dad, what's the plan? I'm not going to say that I did this. Like, it's so unbelievable. Like that family is so demented.
He actually used, I had to give him, just from a writing point of view, he had a cool twist of phrase, something like Karen didn't get lost in loss or something like that.
Yeah. She doesn't get lost in the loss.
She didn't get lost in loss. And so she came out fighting. I got to give him credit for a clever twist of phrase there. That guy, I don't like that. Just something about that guy's face that really bothers me. So it's not, I'm not trying. Well, the thing was my first, what it didn't, and I don't usually say things like that, but when I went to Dedham and for the first time for one of these hearings and your parents were there. And so when Karen's entourage arrived and they went up the stairs, there was, this was the day there was probably 100 people there for the Blues and maybe 500 people there for the Pinks. And so obviously now the stars arrived and the lawyers and everything. It's, people are cheering and booing and all kinds of bullhorns are going. Then it was about a minute later that Nathan arrived. He actually arrived separately. And so he comes, now they come up the sidewalk through the Pink crowd and the Blues are on the other side of the stairs. And he walks up the stairs and he looks down to see, like stunned, to see all these blue shirts. But he stops at the top of the stairs to just sneer at, like the most ridiculous sneer I've ever seen, like sneering at the people at the Blues. And I was like, that was the moment I said, I can't stand this punk. If I still owned a bar, I'd find a reason to throw that guy out just for that sneer.
I don't know. It's just so, like that documentary, I feel like they're not even really saying she's innocent. Like, I just didn't even get that from it. It's like, oh, the only thing so far is like the Google search. right?
Yeah.
But we
Yeah.
know that's debunked. Like, if you know the case, you know it's debunked.
Right.
But like,
Right.
and then she's like saying, oh, well, it's either me or Jen McCabe going down. Like, what the hell is she talking about? Jen McCabe
Yeah.
was never implicated in running him over or beating him up. Like, what is she talking about?
It was
And
really
it's
weird.
just-
Like, and she even said you, like, to Jen McCabe, like she's talking directly to Jen McCabe. It's like
She's psychotic.
yeah, it really is unusual. And Jen hasn't said anything like that I know of either. She hasn't turned it into this weird personal pissing contest between them. And Jen would have every reason to be extremely angry at Karen for what Karen has done to her and her family. Incredibly angry. But yeah, it's perplexing behavior at best. Let's see what else is in the in that documentary. Just a few quick notes from last night you can respond to. Alan Jackson said jury selection, that's the trial. Of course, this is before the first trial he said that, but shows you where their focus is, right?
Yeah. I mean, I believe it. They want cop haters. They want conspiracy theorists. They want, the pink slime people. That's the people that they know what they look like. They're the ugliest people in Massachusetts wearing pink shirts. Like, that's what her cult is. And like, every time she's like, oh, this is my purpose in life. Like, what the hell are you talking about? What is your purpose in life? You got the ugliest people in the country to dress in pink. Like, what did you do? She has done nothing. She's such a lunatic.
Yeah,
like,
it's
I just
crazy.
I can't. Like, every time she opens her mouth, it gets worse. Because like, at first I felt bad for her. And I didn't even want to speak on the side of she did it until I saw like people like harassing the family walking into court, and then her actions. And then I'm like, what is wrong with this woman? Like, she is nuts.
Yeah, there's definitely some very unusual behavior there. But at the end of the day, the jury will weigh evidence, of course, and that's as they should do. What did you? So I'm curious about that. You not being a lawyer, you probably don't know much about this either. But I'm really curious about this impanelment voir dire that Alan Jackson wants, and apparently is the norm in California. And the judge said she is in favor of that too, just not in this case because of the publicity around it. So what goes on in an impanelment voir dire? Do they ask questions to the group in mass? Is the cameras in the room? I mean, what do you think goes on there?
I'm not sure. Because I know that they definitely have a set of questions that they can ask, but in impanelment voir dire, I'm not sure. It just seems like it's a lot more extensive.
Right.
Whether I have no idea. But it seems like they want to get down to like the details. Have you ever been drinking and driving? Which most people in Massachusetts probably have, because, especially older people, because Ubers weren't really a thing. And a lot of these small towns, you can't get a taxi. You can't, like, a lot of people have drink and drive. So a lot of people will empathize with that.
Kyle points out that the judge denied that, but which she did, but I'm just curious as to what it is and how that works. I don't know. It's just interesting because we know there's a sidebar voir dire, like she says. So first the juries get the one-page questionnaire that they have to fill out. And then I believe each juror, as going through this process, goes up to the judges on the bench, and the judge and the lawyers get to look at the questionnaire and then get to ask individual questions to this juror. And how does that different though between this panel voir dire? I mean, panel implies that they're together, right? So, curious about that. Well, maybe
I feel
one
like
of the lawyers will message me.
It does sound like it's like, I don't know, like what I would think is like, you want to be able to, it sounds like they want to be able to see other people's reactions to answers. So are they going to ask them and they're going to answer in front of other people and they see how people react? They're really trying to find the pink people to be on the jury. Like, that's what it is. They want a tainted jury pool. Like, that's their only hope. I just can't. These people are the worst.
Thank you, Grace. I appreciate it. I just responded to a comment. Grace, thank you. I'm trying to do the best as I can to be honest and objective about each particular issue. It's a temptation on the part of all of us to, once we have a perceived side or decisions in your mind, to look there for it. Every, confirmation bias, every other piece of evidence or thing that happens or testimony or person on what side they are, you put them into that box. So everybody on the other side automatically hates Hank Brennan. He's a bad guy. And everybody on this side automatically hates Alessi. He's a bad guy. And it just, I try to avoid that and try to look at each piece of evidence and each thing that goes on objectively and independently. But I'm just curious what goes on with this panel voir dire, because the defense clearly wanted it and thought there was some advantage in it for them. The judge said, no, that's really not going to be allowed here because of the publicity on this case. And, the prosecution didn't want it. They wanted to go with the questions. So I'd like to find out more about that. Hopefully one of our lawyers will email me about this.
I feel like it's a way to get them harassed because they're going to know who answered what. And the ones that get released are going to know. They're going to go to Turtle Boy and they're going to be like, that person said this or whatever.
So if that's the case, if we can't find a legitimate argument that a lawyer is going to send to me as to why this would be an advantage for the defense, then we're going to go with Matt's answer here as a default and say that's really fucking scummy. That the only reason you want an impanelment voir dire is because you want to create more pressure on those individual jurors, and that's just that. Again, that affirms that that's exactly what is going on, despite Alan Jackson's denials here, that they are trying to intimidate. They're trying to intimidate not only the witnesses but the jurors. And so one of our regulars asked who you are. I said, this is Matt Doherty from Boundless Millennial. His channel is on YouTube and perhaps still on TikTok, Boundless Millennial. And he's kind of one of the OGs in this case who started flipping on this late July of 2023. So one of the earliest people to flip on this case, deciding that the logic of the conspiracy theory just didn't make any sense.
I think
something.
I was I guess in the beginning it was Turtle Boy was the only one covering it. Maybe I don't know, but I started looking into it, and that was the kind of stuff that I covered, right? So on TikTok, and then I looked into it, and I was like, oh my god, it's bullshit. I got a few documents. I think it was the original affidavit, and then the defense's response, and in the defense's response, it was Rick Green's stuff, saying he's going up and down stairs, but they released it as if it was while he was at the house. But even in Rick Green's original report, it says it happened before they ever arrived at Fairview. So it's how are they misconstruing that piece? Right. And everything just fell apart from there. Because every single thing that you looked at in that original April 2023 defense filing was bullshit. But they argued it in a very conspiracy laden way that the public responded to. And I was like, oh wow, this is bullshit. And then I had that discussion with Turtle Boy.
You're correct in that report, and if I remember right, it allowed some weirdly short amount of time, say 17 seconds, where John could have gone in the house, got up and down 3 flights of stairs, and got beat up. Again, John didn't go in the house, and that I'm saying, but according to Rich Green's version, so that they arrived at this time, and the health app began showing the stair climbing at say 12:22. And the period that ended was 12:24 and maybe 28 seconds or something weird like that. And it allowed just there was a tiny window within there, which made no sense at all. But that was something that Turtle obviously ignored. Even
in the trial, I don't think that they even disputed. They never even got him in the house in the trial, even with Rick Green on the stand, because they kind of wanted to dispute the timeline. But even if the times were off, he only had a second where his thing was even touching the front door, because it was a 50 feet radius of where he could be on his GPS. And there was only 2 seconds that he was even touching the front door. So even if the times were off, it's he didn't go in the house. He went to the front door, and that's why she always never said he went inside. That's why she was always he went up to the front door, went in the threshold, because she knew that's what it showed. She knew that his GPS didn't go in, but it still doesn't answer anything.
So I guess maybe the jury impanelment this would go like this. So you have 100 jurors in the room, in the court, and 100 prospective jurors in the court, and now you ask them as a group have you followed this in the media? Have you, so instead of the typical questions that they get in the questionnaire, you would have you followed this in the media? You're asking them to a group. So now somebody has to raise their hands and say, yes, I did. That's a much, much harder thing to do. Someone's much more likely to way more likely to sneak through that. And this has already been a huge problem in this case where people snuck through in this jury. So it's one thing to just stay silent when you're in 100 people and you're asked a question like that. But it's a whole other thing to stand before a judge and the lawyers, but in particular, that judge is sitting on that bench looking down on you, and she is authority. She is the law, and you feel it, because I've been on a couple of juries. And
not this judge, though. She doesn't really hold anyone accountable, so, like, you can say whatever the fuck you want.
Yeah,
like, she's not going to hold a juror accountable. Like, are you kidding me? She doesn't do anything. She lets them do whatever they want.
But I'm just saying it's a lot harder for a prospective juror to say, nope, I didn't follow this in the case. I did not form any conclusions on this case. It's a lot harder for them to look at a judge and lie when they're asked eye to eye than it is to just say it, to hide yourself in a group. Does that make sense? Or
yeah, I mean, I think that's true, but I also think that these people, like, even having conversations with them on Twitter or whatever, they shift shape. They don't really have a stance. They don't even know what happened. They don't even have a theory anymore. Like, all of the theories have been debunked, so it's like they don't even know. They just want Karen to get away with murder.
Right.
That's it.
Right.
And it's gross.
The show must go on. The circus outside. I mean, they're probably this time they're going to have jugglers and vendors, and it's a party out there. Boom boxes and music and dance contests, and they already got plenty of dancing out there. It's the last time there was an artist out there doing captions and stuff like that. And I'm not trying to attack her, but I mean, it's just you're turning this into a circus. And
I mean, we should go there with a piñata with Karen Reed's face on it, fill it with little Tito schnips, and let Jen McCabe beat it. That's what we should do outside the next trial.
This is Dedham. If you've got a piñata out there with nips on it, it's not going to last long. I'm telling you, there's going to be a fight. All sides are going to be, but maybe they'll all come together after that. After they start drinking nips, like, who cares about the trial, But actually, when I was out there last time, when I was out there in Dedham for the court TV shoot, while Vinny, after I had done my segment and Vinny was up there, had other guests on, I was talking to some people in the back, and it was in a restaurant that didn't have a bar or a liquor license. And so I met some people, including from the other side, and to be friendly, I'm like, hey, I said, hey, I had heard of them, I was like, I'd buy you guys all around a beer, but this place doesn't have a liquor license. So it was an easy way to offer to buy a round and not have to buy one, right? But so I bought actually some ribs, and I went down and I introduced myself to Nick Rocco, and one of Karen's bodyguards was with him, and I shook his hand, and I offered them some food. And so while I'm sitting there, somebody who is on the defense witness list but didn't testify, and I had just met, and she was one of the ones that I had just offered to buy that drink for, she came over and she put a Jack Daniel's nip in front of me. And I said, oh, thank you. I said, where'd you get that? She pointed to this big stuffed bag that was on the table. She goes, I brought a Canton bag with me. So they actually had a word for it, a Canton bag. So it's such a common thing for these guys to bring a bag full of nips to any event. I mean, and that thing was so full. That was an instant Super Bowl party if they wanted. I mean, it was just. So she brought me over another one. I finished that one. She brought me over another one. I was like, oh boy, I can't hang with these guys anymore.
So I saw something with the DUI guy was saying there was some bombshell coming this week, and I think that what just happened is probably it.
Which
He's
part?
Like, just wait, guys. The feds and whatever this whole thing was where the trial might be delayed. I'm thinking that this was probably the bombshell he was talking about, that he knew about.
Yeah. Let's see. Nothing else really came up today that could have been bombshell, right? Yeah, I guess that's probably it. I mean, the effort to try to get rid of the blood evidence seems, the blood alcohol stuff, it was allowed first trial. It's going to be allowed. The effort to get rid of Dr. Wolf for the accident the neurologist for the state. I mean, come on, that guy is as qualified as anybody could be. I mean, it was just ridiculous. It was just wasted breath today. You know, I thought. Do you agree with that? Or
Yeah, I mean, I don't remember which guy, but like I remember on the witness list there is one missing that was, I thought it was the expoliation guy, that wasn't on the Commonwealth's witness list. So I don't know if they had a couple people say it. I don't remember that day. I remember that was a boring day of testimony where all the doctors at the hospital were there. So I don't know. Maybe they just have one less. Maybe it was more than one that said the same thing. I don't remember.
Oh boy. All right. I'm just looking at the crazy comments in chat. All right. Anything else you want to go into, or it's time to call it a day, and we'll be back Thursday. Anything else you want to go into though?
The one thing that I just want to note from that documentary is they did Lally so dirty with that showing the clock while he was doing his opening statements. I was like, oh my God, they are dragging him so hard.
Oh my God. But, you know, and I had, you know, people, some of the people on this side got a little upset with me in Discord last night, but, you know, because I posted, I said, you know what, I respect Lally and I'm rooting for him, and he worked really hard, and I think he's an honest, decent public servant. I said, but then I still feel frustration for this. I mean, his opening statement was so bad.
It was.
That
it was bad.
That the defense and Karen was celebrating it on the way home.
Mm-hmm.
I mean, how bad can it be that you can't even get the opening statement right? And it's just, you know, he did not give a roadmap for the jury, because the jury, if that's needed in every case, but if there's ever was a case that a roadmap was needed, it was this one, because we didn't even learn the state's theory about what happened until 9 weeks into the trial. So.
Yeah, this is a complicated case too, with so many different witnesses. Like they're not going to remember all their names. Like, what the hell are you talking about? And like, I don't know, but like, if Arca wasn't in the trial, if the feds didn't intervene, Lally would have got his conviction. So even with that, even with the parts that he might have mucked up a little bit, he still would have got a conviction if it wasn't for the feds intervening. So.
Right, and he did some parts well. I think he did a very good job of debunking the conspiracy theory. He just didn't do a good job of laying out the state's case. So whether it was just too much burden on one person, I know he had a little bit of a team with him, but he just really, I didn't have a big problem with his style or anything like that. You know, it could be tedious, but, you know, there's a benefit to that nuts and bolts kind of strategy where the juror looks at this guy and says, you know, he's just a man of the people. He's just doing his job. And so I just think the strategy that they had was really bad, and so somebody could have saved him. Maybe Hank, if they had him back then, or just Morrissey. Isn't that what your job is supposed to be, the DA? This is the most important case in your time's history. Can't you sit down and help this guy come up with an opening statement, a closing argument that you actually don't run out of time for? I mean, a strategy that involves proving your case, and most importantly, reminds you to spend a lot of time with your most important witness, your accident reconstructionist, Trooper Paul. They spent 1 day with him. And it's just, you mastered wall files, great, but a lot more needed to be done.
Mm-hmm. Yeah, she's screwed now.
Yeah, no, I think Hank's on target. He seemed a little low energy today. Maybe he's feeling a little underwear. Maybe he ran into somebody last night with a Canton bag. I don't know. But all right. Well, thank you very much, Matt. Great as always. And hopefully you can join us Thursday. If apparently the next hearing is Thursday now. It's not going to be Wednesday.
All right. Sounds good.
All right.
Thanks guys.
Matt.
All right. Bye.
All right, guys. So we'll just wrap it up there. It's time for lunch. Thank you, everybody, for being here. We do get a little bit more of a mix of people coming in that are from the quote unquote other side, and they're always welcome here. Just be respectful. You don't get on. If you want to engage me, great. Do it politely. Do it respectfully. Tell me your argument. Tell me your evidence. And if you are an accident reconstructionist or a lawyer or former law enforcement, reach out to me. My email is leitskev, Leits, leitskev@gmail.com. And maybe we can arrange that. So, but be respectful. You know, there's no reason not to be. It's why would you basically say, hey, asshole, you want to debate me, and you really think you're going to get a response out of me? That's not going to work very well. So, but everybody, the weather is really improving. It's a little cooler today, and I think we have an inch of snow coming Friday. But as far as Thursday, I you know, I have a meeting Thursday, but I don't think that'll interfere with this, or at the very least, I'll be able to get this started. And as of now, there's nothing scheduled for Friday. I have medical scans going on Friday, and so I suppose if they had something that went on at 9 o'clock in the morning, I would start it here. But as of now, there's nothing scheduled for Friday, anyways. So, I might say thank you to the people like TYJ. Thank you very much for the donation. And Alma with a super sticker, always being generous. Thank you very much. Ashley asked if I'm covering Aiden's hearing. No, nothing ever happens there. That I am convinced that the apocalypse will come and end, and we still won't know what's inside Aiden's phone. Without being disrespectful to this state, some of it seems like a goddamn joke. It's been over a year. There's no reason to deny access to that phone. You've had the taint team go through it. I don't understand what's going on here. Is it the fault of the judge, the prosecution? I don't know, but it's just bizarre. You're just going to have this endless stream of hearings that go nowhere. What is the point? If that's all you're going to do, then just let them go, because you're not really prosecuting a case. You're just doing something weird. It's like busy work for lawyers, I guess. I don't know. It's just amazing to me. No strays ent says, on the dock last night, Karen said she watched John O'Keefe walk inside, but also said maybe John tapped the back of the car. How can these two things be possible? Right. But what she is actually saying is that people get this mixed up a lot. When she says, did I run over his foot? Did I clip him? She's not saying that she thinks now that that's what happened, or that she thought at the time that that's what happened, at the time of the accident or whatever. What she's saying is that morning when she got to the crime scene and made some apparently incriminating statements about herself, that what was going on in her head was she knew that John was hurt, and she was asking herself these questions at the time. Could I have hit him? Could there be some way that I somehow did something and he ended up lying there unconscious and dying in the cold? That's what she's saying. She's not crazy enough, or she's not stupid. She's not going to get up there and say, yeah, I remember hitting him, but I just didn't think it was that hard. Even if that was the truth, she wouldn't say it, because it would be so self-incriminatory that it would be ridiculous, So it's not what she's saying. So I think that's where the difference is. So that's what she's explaining about, did he tap the back of the car or something like that? It's a little bit odd there, because now she's wondering, is that how she's trying to inject this idea that is that how the taillight got broken, which is a little bit new and different. So good job in pointing that out. And Macy became a YouTube member again. I believe Macy's been a member before, but welcome back, Macy. Heisenberg, haven't seen you in a while. Thank you very much. He says TB doesn't even have feelings for his girlfriend. No, or his family members. A psychopath doesn't generally have emotional empathy with anyone else. So the feelings they have are very shallow and simple. So is what it is. All right, guys, thank you very much for being here. And so if there's always a chance you'll see me tonight or tomorrow night. As of now, I am going on Court TV tonight, and on Court TV, well, they've got it scheduled for Wednesday, but maybe they'll change that now that the hearing is Thursday. So we'll see. So if they change that, then maybe I would go live on the air here Wednesday, tomorrow night. But we'll also be watching that documentary. And but hopefully we'll see. I think we're still a month away, but I can't wait for the trees to bloom. It is nice where sometimes you can open your window. Yesterday, last couple of days was in the 60s. So spring is kind of here. It's kind of here. So thank you very much, guys. Thank you, Joe. I didn't see Tom here today, so Tom may still be traveling. And Laura, you're welcome. And she says, looking forward to part 2 of The Body in the Snow. I think it's been a good production so far, just from a production standpoint. I think they've done a good job of capturing the drama and creating a little bit of intrigue without unfairly creating it. So can I go live earlier? What do you mean on trial? You mean on hearing days or at night? I mean, so I went live last night at 7:30. So that's about as early as I usually want to go. But I know that's not always convenient for other people depending what time zone they're in. But I'm sorry, it has to kind of work around my convenience too. So I could maybe occasionally do a special show, but 8 o'clock really works out the best for me. All right, guys. Thank you very much. We'll talk soon.